and then the national public and called her a liar. I need to address that for 1 minute. This text messages that are now part of the record, which now are substantive evidence for you to consider, prove everything that she put in that motion. Everything that she tried to elicit from Mr. Bradley was absolutely 100% true. And not only was it true, she verified through the witness himself that the motion was accurate before it was filed. So for the state to get up here and impugn her credibility, it's not only improper, it violates Berger versus United States, which is a case that says the state can't just get up here and make any argument it wants. And I encourage the court to call him out on it when he steps up here. We have to have candor towards the tribunal. You cannot lie to the court, cannot lie to the public, cannot lie to the jury. And I think that's what he did. So there's other corroboration of our view that she was in this relationship. I think, frankly, based on Mr. Bradley's testimony, Your Honor can separate the wheat from the chaff when it comes to credibility. But Mr. Bradley had 2 chances to correct information that he suddenly developed amnesia about, but he just didn't do it.
How does the timing of the relationship impact financial interest?
Because it's part of the scheme she created intentionally in order to give benefits to her boyfriend. So there's a reason why they fought so hard on this, Judge. I mean, there's a reason that every single subpoena was objected to. Every single question we asked Mr. Bradley was objected to. The jumping up and down, all of the obfuscation. There's a reason for that. They know that if Your Honor finds that relationship started in 2019, that the appointment of Wade itself was improper. And if that was improper, then he had no business as an average citizen, along with the fact that they didn't have approval from Fulton County to appoint him in the first place. That undermines the indictment. It creates a structural impairment in the indictment because he had no more business being in the grand jury room than I did. So that's what they're worried about. And the reason why it's important for the financial piece, Judge, is it's how the money ended up going back to her. She put her boyfriend in the spot, paid him, and then reaped the benefits from it. That she created the system and then didn't tell anybody about it. She didn't even tell her dad about it. So I think if in the grand scheme of things, if you're looking at the totality of the facts, and I've got to sit down here in about 2 minutes to make room for my co-counsel. If you look at it, everything put together, judges, they did this, they knew it was wrong, they hid it, and even when they were called out on it, they tried to create an excuse for it by saying it happened after the fact. We know now from the testimony, Ms. Yurdy confirmed that Mr. Bradley, his text messages were accurate, not his court testimony, but that fact was accurate. The motion is accurate. And so also, I do want to point out, there's no paper trail here for the cash. I know that this was I know she and her father both testified that they kept cash on hand, which, I mean, keeping cash on hand in and of itself is not a problem. When you're a public official and you're required to keep track of gifts that you receive, then you need to keep track of it. But there's no paper trail. There's no deposit history. There's no withdrawal history. There's no receipts, none of that. So even assuming their testimony could be credible, and we don't think that it is, you still don't have enough information to track all that money that she received. And this is just what we know about.
But does the lack of evidence fall on the state? Does the lack of evidence fall on the state? Isn't that where burdens come in?
Yeah, yes, I think they had an obligation to tell Your Honor, hey, this is where the money went. And they certainly had the ability to do that if they could do it. Since they didn't do it, we have to assume they can't. And if they can't, I just want to remind the court of a very important piece of testimony from Ms. Willis that I think goes to credibility of all of the officers of the court who testified. She met with Wade and they developed in 10 minutes after talking about the financial piece, I believe, this cash theory that could not be rebutted. We have no ability to do that. They did, and they chose not to do it. So with that, Your Honor, unless Your Honor has more questions for me, I'm going to sit down and turn the podium over to my distinguished colleague, Mr. Sadow.
Thank you, Mr. Merchant.
Appreciate the court's time.
Good afternoon, Your Honor. I'm going to speak to what I would call a subset of forensic misconduct. And I'm going to assume that all the law that's been provided to you in pleadings as well as emails, you don't need me to tell you what the law is. So I want to just set up how the disqualification and then dismissal of the indictment should take place under the subset of forensic misconduct. Roman's counsel, this merchant, filed on January 8 her pleading, her motion to dismiss and to disqualify. We were in court that Friday of that week in which I made it known that we, that is President Trump, may adopt that motion. I wanted to see what was going to happen before I did so. That Sunday, which would be January the 14th, 2024, DA Willis took it upon herself to go to a historic Black church in Atlanta, having not responded at all to the motion of Ms. Merchant's client, Roman. And she made what we now call the church speech. And Your Honor has reference to that. You didn't necessarily want evidence on that, but you know what the church speech was. It was videoed. It was clear that Ms. Willis had notes. She was reading from notes that she had prepared. It was a calculated determination by Ms. Willis to prejudice the defendants and their counsel. How so? By making an issue out of the fact that the person that was challenged in the Roman motion was Black, without telling the public or the church members or anyone for that matter that the reason that Mr. Wade was being challenged was not because he was Black, had nothing to do with race. It had to do with the relationship that had been alleged and later admitted to by Ms. Merchant. Ms. Willis took full opportunity to prejudice the defendants and then comes along later in a pleading and says it wasn't designed or intended to be at the defendants at all or the defense counsel, which with all due respect is just nonsense. The purpose of that was to get public sympathy, public empathy for what Ms. Merchant had already alleged in her motion. Now, that was a violation of the professional rules of conduct. It was a violation of 3.8G. There's no question about it. It wasn't in response to anything that was said. It was a public statement, extrajudicial, for the purpose of making a comment upon the defendants.
It would be in response to a motion that was filed.
But it wasn't filed in a response, in a pleading. It was filed in response to a motion. And the motion were allegations made. If Ms. Willis wanted to respond at that point, she could have said the facts of the matter. Instead, she misstated what the situation was, took advantage of the opportunity, an ethical violation, and the ethical violation makes it clear that you must refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. Can you think of anything more that would heighten public condemnation of the defendants? Then alleging that defense counsel and the defendants were making their motion based on race and religion. That's as bad as it gets in Fulton County, with all due respect. That's exactly what Ms. Willis wanted done. And remember, the state still had not responded. So then what we get from the state is we get an affidavit filed as part of their response. And that affidavit says specifically, and the affidavit is Mr. Wade, says specifically in paragraphs 26 and 27 that the relationship did not begin until 2022. It acknowledges the relationship and says it didn't begin until 2022. And the pleading that's filed, the state's pleading in response, indicates not exactly that, but it says there was no relationship as of November 1 of 2021. And that up here and say you can't believe, essentially what they're going to say is you can't believe any defense witness because they're defense witnesses. And only people that would tell the truth would be Wade and Willis. I suggest to you that that's not accurate. I suggest that the testimony that Mr. Wade gave and Ms. Willis gave, and I'm specifically dealing now with the timing issue, without getting into anything else, that brought forth a true concern about their truthfulness and being what is required of a lawyer in this state, which is candor toward the tribunal. And that's 3.3 of the professional rules, specifically small. Make a false statement of material fact or law to a tribunal. So that's, as I posited to the court, that's the second ethical violation. And then you also have 8.4 of the professional rules. It says it's a violation of the Georgia rules of professional conduct for a lawyer to, and that's A4, engage in a professional conduct involving dishonesty, fraud, deceit, or misrepresentation. Now, do you have to find that Wade and Willis lied? No. What you need to be able to find is that there is a concern, a legitimate concern based on the evidence in this case about their truthfulness, a legitimate concern about the truthfulness, which equates to an appearance of impropriety. Because once you have the appearance of impropriety under forensic misconduct, the law in Georgia is clear, that's enough to disqualify. So why should you find there's a concern with their truthfulness? ERT is the first one. You have that testimony. But then we go to what is the most obvious indication that Willis and Wade were not truthful on the point of timing, and that's Bradley. Defense Exhibit 26 came into evidence. Defense Exhibit 26 comes in and says, and you know I went into this the last hearing. It says that on January the 5th, 2024, at approximately 9:49 a.m., there's text messages that are exchanged between Ms. Merchant and Mr. Bradley. And the text messages go like, just date, and that's from Ms. Merchant. Ms. Merchant says, do you think it started before she hired him? Bradley, who we now know from Defense Exhibit 39, has been texting with Ms. Merchant for a number of months. This is not the first time. This is months within the communications between the two. Mr. Bradley says, absolutely. Now, absolutely is not a speculative word. That's not speculation. That's a definitive statement. And Bradley then, unprompted, as this, and unprompted is important. It started when she left the DA's office and was a judge in South Fulton. It goes on, Ms. Merchant says, she liked it started when she left the DA's office with the appropriate emoji or whatever one would call it to say it was liked. And then Mr. Bradley said they met at the municipal court CLE conference. Again, unprompted. He's now definitively telling Ms. Merchant when this relationship started. Ms. Merchant says, that's what I figured when he was married. And then Ms. Merchant says, and we're now talking about a couple hours later, she texts and says, upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And Mr. Bradley responds, no, municipal court. Thank you. Doesn't say it didn't start then. He doesn't suggest that she's wrong other than magistrate court municipal. Now we have that and it's in evidence. And what does Bradley do? He knows that he's put himself in a position that if he testifies truthfully on the witness stand, Your Honor is in a position to be able to find, if you choose to, that both Willis and Wade lied. So what does Bradley do? Look, you were an assistant U.S. attorney. You know how this works when you have witnesses in this situation. Mr. Bradley did everything he could possibly do to evade answering questions. No recollection, couldn't remember, it was speculation. Anything he could possibly say that would cause Your Honor not to believe that Bradley knew when this relationship started. I suggest they were clear-cut lies, and the truth is in Defense Exhibit 26.
And so if we take that view, that he thoroughly impeached himself, that he did not give truthful conduct, what's left standing? Generally, you would see someone who's impeached, perhaps we have some kind of core that you could point back to and say, that's the time he was telling the truth. In these text messages, is it ever definitively shown how he knew this and that he actually did know it, other than in just a assertion outright? Absolutely. Usually if a state has a witness that goes sideways, they've got him locked in. They've sat down with a detective, got a full statement. We don't have that here.
But what you have is a text message, which is a prior statement of Bradley that he did on his own, that was not given to him by someone else. The only thing that the court has just noted is, how do we know he wasn't speculating? Because you don't have to accept the fact that he wasn't speculating. The cases that I provided, I think by email yesterday, the first dealing with that, you can disbelieve that testimony and draw a negative inference. That's the Ferguson case. On Lee, the other case, you can simply take the prior inconsistent statement as substantive evidence. It has the same value. And that's what I'm asking you to do, to take what was the unprompted statement in Defense Exhibit 26 of Bradley and take that on its face value, that is an indication that Bradley in fact knew and had said he did. If you accept that, you have to have concerns about the truthfulness of Willis and Wade on the timing issue.
And I don't know if this is something maybe one of your co-counsel were going to address as well. We heard about kind of the law that applies, how we're outside kind of the orbit of the core of cases we're used to dealing with here, where it deals with side switching or where someone is in the relationship, the client relationship. The proposition you're putting forward now is that if a representative of the state, the lead prosecutor, the district attorney themselves, says something that's untruthful on the record, that is something that immediately has to be proactively policed by the trial court. Is basically what I'm getting at is, where in the law do we find the remedy to an untruthful statement? Generally, we send you down the street to the bar, right?
And that's why I gave you the cases of Registe and Edwards yesterday. While those aren't prosecutorial cases or dealing with prosecutors, they deal with counsel. And in both those cases, the trial judge found ethical violations on the part of defense counsel, or potential ethical violations. Went through the ethical violations and said, based on that, you're disqualified. You cannot be the attorney of record in this case. What's good for the goose is good for the gander. If defense counsel can be kicked off of a case because of ethical violations, I suggest the same thing can happen for prosecutors when the ethical violations deal with truthfulness, candor to the court, extrajudicial statements. Those are the things that this court can rely upon and say, based on those, again, I find an appearance of impropriety.
Where would be the limiting principle? The district attorney signs every indictment assigned to this courtroom.
No,
Does that mean she's off every case?
No, it would be when
if I found that she's untruthful. Is that what you're kind of suggesting, though?
You don't have to find, again, I'm not saying you have to find she was untruthful or that Wade was untruthful. You don't have to make a finding of fact that they lied. All you have to do is make a finding of fact that you have genuine, legitimate concerns about their credibility, about their truthfulness. And once you find that, then you can apply Registe and Edwards.
Well, but it's the same principle, though. If I have genuine concerns about her truthfulness on a particular occasion, how do those not spill over into every criminal case a district attorney brings?
Well, it's because she testified under oath, and so did Mr. Wade. They didn't have to testify falsely. They could have testified truthfully. They could have indicated that the relationship, the timing was in fact before Mr. Wade was hired. They chose not to. And in that sense, that dishonesty, that constitutes a violation of their ethical responsibilities. This is not signing an indictment. This is not filing a pleading in which both sides have their own positions. This is a requirement that every witness has to tell the truth under oath. And if they don't tell the truth under oath, or there's a significant concern about their credibility, then they're violating their ethical rules. And as anyone will tell you, as Your Honor already knew from when you were a prosecutor, prosecutors are held to a higher standard. They're the ones that are supposed to be seeking justice. They don't have a particular, they're supposed to be disinterested. When you have the lead prosecutor and the DA giving what I suggest to you is untruthful testimony, based on what Yerty has said, based on what Bradley said in his text, based on the whole way it was presented to you. Bradley didn't want to testify. He first came up with his attorney-client privilege thing on that. Then Your Honor fortunately went into that. And then when Bradley knew he had to testify about it, you saw what happened. You can draw the inference, as I've suggested on Bradley, that what he said in the text message, Defense Exhibit 26, is true. The relationship, in fact, started prior to November 1st of 2021. That ERT says that. And now, without getting into any detail, the cell phone records. The cell phone records show that during that period of time from, let's say, April 1 of 2021 to November 30th of 2021, that there was a considerable number, 35 or more occasions where it appeared that, based on the records, that Mr. Wade was down in the area where Miss Willis was staying in the Yerte's apartment. But more important is there are 2 occasions, and the state has not challenged those. There are 2 occasions where the records reflect that it appears Mr. Wade spent the night at that apartment. The state may say, we don't accept that, but they didn't challenge it. And even when they brought forth what they brought forth today, supplemental 2 and 3, they didn't challenge it again. So what does that suggest? That's corroborating evidence of what Yerte had said, of what Bradley said in his text message. It's also impeachment evidence as to what Wade and Willis said about how many times.
Is that a significant, in terms of just the times? Didn't Mr. Wade testify that he was there at least 10 times during that time frame? You've now found 35.
Well, minimum of 35.
Okay.
But never overnight. He said he never spent overnight.
Put that to the side, though, just in terms of the fact that he did say he'd been over there, that he'd visited the place, and I would presume he wasn't obviously keeping a very good accounting of it, but that wasn't something that was entirely denied.
If you're asking me, do we win on the point that he said more than 10 or around 10 and we say 35, do we win on that point?
Sure.
No.
Okay.
It's not determined.
The overnight rate might raise some more concerns. Understood.
Yeah, it does. And that's the reason why we highlighted it in the affidavit of Mr. Middlestadt, because that is suggestive that they were not being honest to the court. So then, how much time have I used? Have I?
I'm letting them use the hook. So suggestive, again, raising issues. I'm wondering about burden. Is it we're dealing with a preponderance standard?
We are dealing with a preponderance standard, and it's our burden.
Yeah.
No question about that.
So does suggestive get us there?
No, but it is corroborating evidence that we did put up. And that's what the purpose of the cell phone records. They corroborate what Yerte says. They corroborate what Bradley said in Defense Exhibit 26. And they impeach, to that extent, Wade and Willis's testimony. So if you find by a preponderance of the evidence, so I can finish this up, if you find by a preponderance of the evidence that what I call subset of forensic misconduct, ethical violations, has been shown, and that there is a significant and legitimate concern about the truthfulness of Wade and Willis, they're disqualified. Now, obviously, factual findings are yours, but the law allows you to do that. You don't have to do it through an actual conflict. That's the other side of the equation. And that's what I've argued, and I think that's what Mr. Gibbons can argue.
Before I let you go, though, this is an interesting classification. You're saying forensic conduct isn't just commenting publicly about the case indicating guilt. You're saying forensic conduct is just anything a district attorney says falls into that box?
No, I'm saying that
improper,
that
obviously.
Forensic misconduct as a subset of that would include violations, ethical violations, which impact the ability of the defendants to get a fair trial, as well as impact the court's ability to have faith that the prosecutors, these 2 prosecutors, are acting in good faith in their own conduct. Same idea dealing with, as I said, defense counsel in the 2 cases I mentioned. Ethical violations can give rise to disqualification, and I suggest we have that here.
All right. Thank you, Mr. Sato.
Thank you.
Where's the shot clock when you need it?
Right there.
Your Honor, I want to address very directly here. What we have is a systematic, continuous pattern, a calculated plan, evidencing a design to prejudice the defendants in this case, in the minds of the jurors. This is what we have seen. This isn't the problem that the district attorney has. It's not that the district attorney had some sort of brief off-the-cuff statement in an interaction with a reporter like in Williams. That's not what we have here. We have someone who sat down wrote out her speech, wrote out her plan, who sat down for whether it's 2, 3, or 6 times with the editors of Find Me the Votes and told and got her message out about this case before it was supposed to be tried in this courtroom. And so that is the problem that we have. We have a pattern of forensic misconduct on behalf of Miss Willis.
So, I mean, we have a pattern of public statements being made. I take it you or your team has dived in and read the book. I know she was asked about specific portions in it. The only case that I can find actually talking about when someone crosses the line on public comments is that Williams case. And it talks about there has to be an implication of saying a particular defendant is guilty. And it even denied it, right? So have you found any case in Georgia where they actually said that a prosecutor had gone too far in their public comments? Does one exist?
Well, number one, thank goodness it doesn't happen often. Sadly, it's already happened here. Now, in Williams, the prosecutor had one response to an inquiry the court found it was improper, but did not have this pattern. Now, it doesn't necessarily mean a comment about the quote guilt or innocence, although that was the pattern in Williams. It's the improper comments by a prosecutor. For example, in Williams, they cite the nature and consequences of forensic misconduct in prosecution of criminal case, a 1955 Columbia Law School article, and how prophetic that was. When Williams cites that case in that law school article, they talk about an awful lot more than simply the comments about specific guilt or references to guilt. What you have here, Your Honor, is a comment, and we can't look at it doesn't apply only if a prosecutor said, I think the defendant is guilty in my mind. No, it's more pernicious than that. What we have here is someone who sat down and drew up a plan for 2 reasons. And what she did reminds me of what the court in Estes v. Texas talks about, and that is that pretrial can create major problems for a defendant, indeed more harmful than publicity during a trial, for it may set the community opinion as to guilt or innocence. That's what we have here. That's exactly what we have. And the court in Estes talks about the power of the television camera. So what do we have, and what did this prosecutor do? What she chose to do is sort of what was criticized by the Supreme Court in Shepard v. Maxwell. Legal trials are not like elections to be won through the use of meeting halls, the radio, or the newspaper. That's exactly what we have here. What we have is a deflection. What this is all about is more insidious than just making the comments that she's made. It's a deflection. What she chose to do was to say, okay, I have done my best to hide the relationship with Nathan Wade. And Nathan Wade has done his very best by filing false documents in his divorce case to hide his relationship with Miss Willis. Now, and so what did they do? Well, when Miss Merchant filed the motion to disqualify, now the game plan has to change. The game plan I call the deflection begins to take place. The deflection is when the district attorney sat down and wrote out. Look at I'm sure the court has. When you look at that video, it's in evidence of her speech at church. She has written out everything and she's reading from it. She chooses to deflect. The court asked earlier, wasn't she really responding to the motion that had been filed against her? Would that she had. Because if she had, she would have looked the members of that church in the face and say, there's been an allegation that I had a romantic relationship with Mr. Wade. And ladies and gentlemen of this congregation, it's true. She didn't do that. She chose to deflect and to do 2 things that are reprehensible for any lawyer, but particularly for a prosecutor. She chose to pull out the race card and the God card. That's what she did. And she wrote it out. She went on to deflect away from the allegations in the Wade motion. And she she's saying why in her talk, public discussion with God, why are they only attacking one in reference to Mr. Wade? And then she goes on to say, God, isn't it them playing the race card when they only question one? Now, if she had been truthful with that congregation, truthful with the community, she would have said, I had a relationship with him. Good, bad, forgive me, whatever. That's what she should have said. But she chose to deflect and say the reference to them and the others and they. It's obviously a reference to the motion filed by Ms. Merchant. They choose to go after the black man. And she then goes on, again, deflecting away and deflecting to what I call the third rail in American society, choosing somebody on the other side of being a racist. So-and-so is a racist. They're racist. She was the one playing the race card in a way to try to deflect from her own conduct. She goes on to say in discussions with the Lord, God, is it that some will never see a black man as qualified no matter his achievements? Again, the deflection. What is she saying? The listener is not necessarily in that audience in that church. The listener is at Fulton County. The potential jurors who will come into a courtroom and say whether or not they can fairly judge the evidence or judge the defense in this case. She chose to inject race into the minds of the listeners and virtually everybody in this community, and literally everybody in this country has reviewed and analyzed her speech that she made in a premeditated way. And in bringing in not only the race card, but also in bringing in the religious matter. This is exactly what Hammonds v. State and our Supreme Court talks about, condemning as an inflammatory appeal to the jurors' private religious beliefs. Why would she do that? To deflect. But now, not only is she deflecting, but she is then going forward and, in a way, telling the community, telling the congregation that God is on her side, not on the side of these people. God, she said, and when she's talking, and she's saying, God, pray for their souls. I, meaning God, qualified you. I qualified your imperfect, flawed self. I see you in every hour. Do my work. As though she's telling the folks in her very, very, very implicit way, injecting into the minds of the jurors, God wants me to win this case. God wants me to prosecute this case. And why is he going, and why are these others going after the black man? Well, the answer is very simple. As we said in our brief, we didn't mention Mrs. Cross, Ms. Cross, the white female, or Mr. Floyd, the white male, because there was absolutely no evidence and is no evidence of a personal romantic relationship with them in which she obtained these benefits. That's the reason why we did not do that. So she goes forward with her with the deflections. That's exactly what she does when she goes forward, and she talks about a planned interviews time and time again with authors of the book, Find Me the Votes, where she's talking about a case that's going to be tried in this courtroom. It's reprehensible.
So in that specific, instance, setting aside the fact that she was willing to go on the record before a case had even reached the jury, what specific statements from that book do you contend cross the line?
Well, for example, she's saying, she goes on to talk about all the calls that she gets from people calling her racial terms. and all the calls are racist. What she's trying to do, and I think there's a reference in there to MAGA people, whatever. In that, what she's really saying is that those people calling me up and making those claims or those horrible racial slurs to me are really people on their side of the fence. That's what she's doing. And there's no reason, Your Honor, ever for a prosecutor to sit down and go forward with this kind of interview. She did it in Find the Votes. But then what really happened here is this hiding of the relationship. Because in hiding the relationship, they have done such a good job. Mr. Wade filed false documents in his divorce case when on May the 23rd, May of 2023, talking about, have you ever had sexual relations with a person during the course of the marriage or including the period of separation? He's still married. He doesn't have a divorce decree, but his answer is none. Then he's asked whether or not on any occasions he's entertained or been entertained by someone, for a woman, a member of the opposite sex, in this case a woman, from the date of the marriage to the present, talking about place and time and all that. What is the answer? None. Why does he do that? He does that because he doesn't want to tell about the relationship that he has with Miss Willis and the benefits that he has gotten and that he gave to her. That's exact. And what these answers are absolutely reprehensible, that a member of the State Bar of Georgia would file these answers that are inaccurate. What does Miss Wade do? Excuse me, Miss Willis do? Miss Willis on her. Financial report on whether or not she has gotten anything of $100 or more in value from a prohibited source. The court asked earlier about what a threshold might be. Well, for the financial report, it's $100. That's it. She doesn't report any of all of the benefits that she received from Mr. Wade, all the trips, all the entertainment, all the 3 nights in the luxury suite in Aruba, all of that. None of that is here. And they say, oh, well, maybe it all balanced out, even though I can't prove it with the cash. Well, that's like saying, did I give the court a Christmas present? Well, maybe I gave the court a Christmas present and the court gave me one back. The court has to fill out a form whether you got a Christmas present from anybody. You say, I got one from Mr. Gillen. You don't say, nah, well, I gave him one back, so it really evens out. They're false reports. And because they're false, what they had to do is they had to say, uh-oh, Miss Merchant has caught us. And so what we're going to do is we're going to get, in our response, we're going to get Mr. Wade to file a false declaration, which he does. His declaration in this case is false. And the evidence showing that that is false as it relates to the timing, and the court asked earlier, why does it matter, if the relationship was before or after November 1, 2021? The answer is they think it's important. And frankly, I do too, because when she's hiring somebody and she's not telling the people who are going to be paying the tab up to $700,000, hey, I just hired my boyfriend who's taking me on trip to the Caribbean and taking me down to Aruba and taking me to California. Hope you don't mind. No disclosure whatsoever. And the money flows off. But because they got caught, they then commit what I think is an additional component of forensic misconduct, and that is fraud on this court. When they filed that affidavit, and now it's been proven, I think, beyond virtually any doubt that the relationship occurred prior to November 1, 2021, and the benefits that were there. And we don't have to run around. And I love we've got all the records showing from Mr. Wade about the payment for these trips, for the cruises, for the flights, all this stuff. What's the only way is they sat around and met together before they testified. and came up with their story. What's the only way that they can save themselves? Pay no attention to the records. Pay no attention to the airlines and to the flights and the vacations and the cruises. I paid him back in cash. Show us your receipts. Where did you take cash out of the bank? Ever? Oh, I don't have any. Well, show us the. Deposits that he had. Well, never. We don't have any. What we have here is a fraud on this court, which has been shown, I think, overwhelmingly by the evidence and overwhelmingly through not only the testimony of Yurdi, the testimony of the emails and the text from Mr. Bradley to Ms. Merchant, as well as all the documents that they had no answer to other than the just trust me, I gave him money, it evaporated, I don't know where it came from, and he doesn't know what he did with it. Just please trust us and believe us because it's our only way out of the trap that they set for themselves. These people, sadly, and I hate to say I was a former, as the court knows, I was a prosecutor for about 3.5 million years, it seems, in the federal building, and I was an assistant DA beforehand. Prosecutors don't act like this. Lawyers don't act like this. These people, Your Honor, is a systematic misconduct, and they need to go. Thank you.
Your Honor, I'm going to cover a few factual details without overly rehashing what has already been said. During the pendency of this investigation in this case, Mr. Wade and Ms. Willis basically lived Robin Leach's lifestyle of the rich and famous. And they did this riding on the backs of the defendants in this case, funded by the taxpayers of Fulton County and the state of Georgia, with the money that was paid to Mr. Wade through the contract that Ms. Willis got him. That money flow, that is the personal interest that you asked about. She was personally benefiting from the position, from the job, from the scope of the investigation, from the scope of the indictment and how they conducted it. And we know this, we know from the records that have been submitted before the court that Mr. Wade paid at least $17,095 towards this relationship. That does not even include the various dinners, the day trips that both Wade and Willis admitted to. So that number is likely even higher. We know from the documents that Ms. Willis only paid $1,394 for an airline ticket. We know from Ms. Yurdi, who was pretty much uncontested, there was no evidence presented by the state disputing her time frame, that relationship started in 2019. She saw them kissing, she saw them hugging. Now, whether or not they had sex before January of 2022, I do not know. They admitted sometime in early 2022, and I found it curious that they both, Wade and Willis, just went straight to the sex. So maybe that's when they started having sex. I do not know. But the relationship predated that. And their combined and overly suggestive focus on that is a red herring to this court and to the defense, that that's what they want you to focus on. They want you to ignore all the evidence that the relationship predated that. The relationship started in 2019. The relationship continued through 2020. The relationship continued through 2021. Looking at the cell phone communications, just in the first 11 months of 2021, over 2,000 calls, almost 9,800 texts. You know, I don't even think love-struck teenagers communicate that much. The November 29th and November 30th escapade. Phone call from Miss Willis, between Mr. Willis and Mr. Wade, 11:32 that night. Shortly after midnight, the phone starts traveling down from where Mr. Wade lives and ends up where Miss Willis is staying. And he's there until roughly 4:55 a.m. None of the excuses, none of the explanations that Mr. Wade gave going to the Porsche experience, going to dinner, going to the airport, none of that explains that. I'm pretty sure the Porsche experience isn't open in the middle of the night. I'm pretty sure that there weren't any restaurants that he drove 30 to 45 minutes to go eat at in the middle of the night, right after he talked to Miss Willis. Teenagers have a name for those kind of calls and those kind of escapades. I won't go into it. But the documentary evidence, the objective evidence, undercuts everything that both Wade and Willis said. When you look at Miss Yurdy, again, she unequivocally said that relationship began in 2019. She saw physical evidence of a romantic relationship. Mr. Bradley, in the text messages, which are substantive evidence, said that that relationship began in 2019. Again, his January, temporary amnesia that somehow was triggered temporarily after Gabe Banks called him, we can question that. But we do have statements from him that specifically said that relationship predated Mr. Wade's appointment by Miss Willis. You asked, well, in Mr. Wade, you asked what the materiality would be. How much is enough? Well, clearly 17,000 is enough. But Fulton County has told us, has told Mrs. Willis what the materiality is. It's $100 in a year. She twice signed declarations, certifications that she did not receive any gifts. And even under her strained explanation, there were monies, there were gifts, there were dinners, there were excess contributions flowing her way that exceeded $100. Her excuse, her explanation, well, I just paid it in cash. That just does not stand to reason. It does not hold up to the light of truth. Anyone that has ever been in a money laundering trial, a forfeiture trial, if that's the explanation we give the state, they laugh. Oh, I just gave cash. I have no records for it. I have no source for it. The only thing that she could say that was a source for the money, because at times she said she was down to $500 to $1,000. The only explanation she had is, well, sometimes I go to Publix and I may get an extra $50. That shows up on your debit card or your credit card. Did they bring those records in? No. Did they bring her bank accounts in? No. Did they bring any documentary evidence in? No, they did not. And why is that important, Judge? Yes, the burden is ours. But under OCGA 24-14-22, if a party has evidence in such party's power and within such party's reach, by which he or she may repel a claim, and they had that power, Ms. Willis had that power, Mr. Wade had that power, that they can repel the claim that we have made against them, but they admit to produce it, or if they produce weaker evidence, then you, as the fact finder, Judge, it is in your power to disregard that, and a presumption arises that that documentary evidence that is in their possession that they failed to produce supports our claim. And that is something that the state relies on regularly in criminal trials. And that is something that the court should rely on in this case when formulating its factual findings. And we know that both Mr. Wade and Ms. Willis have some difficulty expressing the truth when it comes to their relationship in these cases. We know Mr. Wade lied in his interrogatories multiple times. We know Ms. Willis falsely certified that she hadn't received any gifts from anybody. And Mr. Wade clearly was a prohibited source. He was someone doing business with Fulton County. Anything over $100 in a year, she had to put down, and she put 0. And it defies imagination that she could somehow forget about all these trips, all these dinners, all these day trips, and not put that money down. You had asked, I think it was Mr. Gillen, did she say in that church speech or anywhere else that the defendants were guilty? And I think she did in that church speech. She said in that church speech, and she was talking about a conversation that she apparently had with God, talking about herself. She said, this leader has a trial conviction rate of 95%. She said, the trial team this leader put together has a conviction rate of 95%. I do not see how anyone, and I think that was purposefully intended by Ms. Willis, I do not see how anyone can listen to those two statements and not take that Ms. Willis is telling everyone in that church and everyone that's going to hear that in the media afterwards that these defendants are guilty. That is what she was saying. She is a prosecutor. She's familiar with the U.S. v. Berger. Every single attorney that's ever been a prosecutor is familiar with the dictates of that U.S. Supreme Court case. That is a foul blow. That is improper, and she violated pretty much every tenet a prosecutor must abide by to seek truth and justice in a particular case. So, Judge, when you're looking at this, the uncontroverted evidence shows that they had a relationship prior. The uncontroverted evidence shows that Mr. Wade lavishly spent on Ms. Willis. The uncontroverted evidence shows that the money that he was spending on Ms. Willis came from this contract that he had. And I'm not just talking about the contract as a special prosecutor, but there's also those other questionable contracts that no matter whom his partner seemed to be, they also got. There is a direct financial benefit that Ms. Willis received from this. And Judge, looking back at what Judge McBurney said, if merely hosting a fundraiser for a political opponent of a putative defendant creates not only the appearance, but an actual conflict, then what Ms. Willis has done since then in this case creates an actual conflict. But again, as prior counsel has stated, we only need to show the appearance of a conflict. And we have done that by a preponderance of the evidence. In fact, I believe we've shown an actual conflict. But nonetheless, the result should be that Ms. Willis and her office should be disqualified from this case. We still have a few more minutes. I think Mr. Cromwell may have something to say. Thank you, Your Honor.
Thank you.
Good afternoon, Your Honor.
Yeah.
Harry McDougall for Mr. Clark. I'm going to talk further about conflicts, and I'm going to assume the most difficult standard for us to meet, which is actual conflict. But before I begin that, I want to add just a little bit to what has already been said about the standards that apply to prosecutors. Our appellate courts have said often, the administration of the law, and especially that of the criminal law, should, like Caesar's wife, be above suspicion and should be free from all temptation, bias, or prejudice so far as it is possible for our courts to accomplish it. The first occurrence of that I can find is Nichols v. State more than 100 years ago, 1915. The most recent, Registe v. State in the Supreme Court in 2010, although they don't refer to Caesar's wife. That requirement is also embedded in the prosecutor's statutory oath, 15-18-2, which requires impartially and without fear or favor discharge my duties as district attorney and take only my lawful compensation, so help me God. The general rule on conflicts of interest for lawyers is in Rule of Professional Conduct 1.7. And we all know, it's all drummed into us, that we cannot have a conflict of interest. And if we do, we have to withdraw or we will be disqualified. The basic idea is that a conflict of interest impairs the lawyer's independent professional judgment. That's the test of a conflict and whether it can be waived and whether it's disqualifying. And that conflict is not just financial. It can be any conflict that impairs your independent professional judgment. And you see that in McLaughlin v. Payne. The court asked what was a personal interest for purposes of disqualification. It's anything that impairs professional judgment. That's reflected in the ABA standards that were quoted by Mr. Merchant, which list the prosecutor's personal, political, financial, professional, business, property, or other interests or relationships. And that's really embedded in the prosecutor's oath to act impartially. And the earlier disqualification order by Judge McBurney was based on political interests, not financial. What my colleagues have described as forensic misconduct is also cognizable as a conflict of interest based on that footnote in the Williams case. The root of all of the problems that we see in this court right now is a conflict of interest arising from their individual personal interests in perpetuating and concealing their relationship. That's the original sin from which all of the other problems flow. There are 6 different actual conflicts of interest in this case, any one of which warrants disqualification, but collectively practically compelling. First, the financial conflict that's already been covered. Second, the personal ambition, political ambition. Third, there's a dovetailed or complementary pattern of deceit and concealment of the relationship and the money. Fourth, the speech at the church. Fifth, the motion for protective order that the DA filed in Mr. Wade's divorce case. Sixth, the way the state has conducted the defense of this motion to disqualify, especially the hearing. On the financial piece, the court asked for a limiting principle and asked about materiality. The limiting principle is whatever impairs the independent professional judgment of the lawyer. That is applied routinely. We have a county code section that flatly prohibits gifts from contractors, period. We have, by analogy, the federal bribery statute, which has a threshold of $5,000, 18 U.S.C. 666. The court asked about burdens and inferences. The court can draw a negative inference from the state's failure to produce evidence to support the invisible magic cash balancing theory based on State v. Thomas, 311 Georgia 407, particularly footnote 19. As to the timing question that the court asked about, there were 2 contracts for Mr. Wade executed after they acknowledged the relationship began. Each one of them afflicted or conflicted under county and common law. The second conflict is her political ambition, for which he was previously chastised by Judge McBurney. And that's also present in this book. The inside flap of this book says that they were given, quote, exclusive access to thousands of secret documents, emails, text messages, and audio recordings. The court has twice denied defense motions to unseal special purpose grand jury materials. She helped herself to get the glory of this book. I introduced certified copies of a number of county code sections. I'm not going to walk through those, but I'll tell you why they matter. the stack of law from the state constitution down to the county ordinances imposes a regime on the DA under which she has three obligations. She has to go to the county commission to get approval to pay him like she did. She cannot accept gifts from a prohibited source. She has to disclose the gifts that she received. She evaded all of those requirements. Section 2-69 of the county code prohibits gifts from prohibited sources, which he was. There's no boyfriend exception. The disclosure forms, the evidence is sufficient for you to find that her disclosure form for 2022 is false and that it is a false writing. That's an actual conflict of interest between her duty, legal duty of disclosure, her legal duty of candor as a prosecutor, and her private and personal interests in concealing the relationship, concealing the gifts, and keeping the gravy train rolling for as long as possible. His part in the pattern of concealment is a story you see in many divorce cases. The husband is hiding things from his wife. How much money he's making, the other woman, and what he's spending on the other woman. And he got on that stand, lied in his interrogatories, and he got on the stand and he lied about lying in the interrogatories. And the lawyers for the DA's office, they just sat there and let him do it. They did nothing to correct obviously perjured testimony. In and of itself, that warrants disqualification of every one of them. The reason they lied and covered it up was to avoid the trouble they're in right now. That served their personal interests to the detriment of their public duties as prosecutors. The speech at the church. I want to focus on why she did that. Mr. Gillen talked about that. She did it to deflect attention from her own misconduct and that of Mr. Wade. She violated her public duty as a prosecutor to serve her personal interests and the personal interests of her boyfriend. That is a disqualifying conflict between her personal interests and her public duty that is actual, operational, and materialized, and it rests on undisputed facts. The next thing that she did that was a disqualifying conflict of interest was the emergency motion for protective order that she filed in the divorce. I filed a certified copy of that as Exhibit 37. She sought a protective order under the Apex doctrine on the grounds that she's the DA. The whole filing is expressly predicated on her status. As DA. In fact, she never lets you forget it. She says it 27 times in 12 pages. In that filing, speaking as DA, she said, the circumstances, quote, suggest that defendant Joycelyn Wade is using the legal process to harass and embarrass District Attorney Willis, and in doing so is obstructing and interfering with an ongoing criminal investigation. In the prayer for relief on page 11, she asked for 6 months to, quote, complete a review of the filings in the instant case, investigate and depose relevant witnesses with regard to the interference and obstruction this motion contends. There's no sugarcoating it. That's a clear violation of Rule of Professional Conduct 3.4H, which prohibits lawyers from making threats of criminal prosecution to gain advantage in a civil case. She abused her power. She abused her position to threaten her boyfriend's wife with criminal prosecution to gain advantage for herself and her boyfriend in her boyfriend's divorce. She violated her public duties not to make that kind of a threat in order to serve her private personal interests and those of Mr. Wade. Another actual operational conflict. The last category is the conduct of the defense of this hearing. There were a lot of objections made based on attorney-client privilege during Mr. Bradley's testimony. Most of those objections were made by the state, but the privilege being asserted does not belong to the state. It belongs to Mr. Wade. That shows that the DA's office is serving the personal interests of the DA and Mr. Wade in carrying out further concealment and cover-up of their relationship, and not the cause of justice they are sworn to serve. That is a conflict of interest. It's a continuation of the wrongful pattern of concealment and cover-up that they've engaged in since the beginning. But now they've enlisted the entire office in the enterprise. In the written response to the motion to disqualify, they said this, and I quote, "Should be absolutely clear, there is no evidence that DA Willis derived any financial benefit from Mr. Wade." That's on page 15. Flat out false. 10 lawyers in this case put their name on that, starting with the DA. So throw another log on the bonfire of conflicts of interest. The problem here is the DA cannot distinguish between her personal interests and ambitions on the one hand and her public duties as a prosecutor on the other, and apparently neither can anyone else in their office. Of the 6 conflicts I've identified, only one is subject to a conflict in the evidence. This is a case study in what happens when you operate under a conflict of interest. It's put an irreparable stain on the case. Think of the message that would be sent if they were not disqualified. If this is tolerated, we'll get more of it. This office is a global laughingstock because of their conduct. They should be disqualified and the case should be dismissed.
Your Honor, there's not much oxygen left in the room. We delineated the times based on the whole presentation. Would Your Honor consider some time for us in rebuttal?
No.
Okay, well then, could I reserve what I had, 5 minutes for
Sure,
rebuttal?
that's fine.
All right, thank you, Your Honor.
All right, let's take a quick 5, and we'll be back at 2:40-ish to hear from the state. Thank you.
Test, test, test.
I hear you. Thank you. Thank you, 3-star. All right. I appreciate you. Look at they nervous. She's unmoved. Your whole career is about to evaporate right before your very eyes. I have some lashes. Did the state pay for them lashes? Did we pay for them lashes? Let me stop. Had your daddy up there lying. Got the whole office line for you probably been that bully boss. You know, there was some stuff out there with her firing people and stuff, so she's Terminator. Yeah, they about to throw the book.
Sir.
About to toss it. Poker face, yeah. Yeah. And act like she's unmoved. Yeah, I'm unbothered. And her heart probably jumping out of her chest. I'm curious.
This man. This man.
Just sit.
He felt like, get this camera off my face.
All right,
Now
we're
she
back
gets a
on
little
the record.
worried.
Stay ready.
Yes, Judge. I just am trying to get to where I can share my screen.
We need to add you as a host then. What's your profile name on the Zoom? Your screen name on the Zoom.
Adam, a body.
All right, just making sure. Bear with us. Do you need it right away?
No, I can start without.
All right, floor is yours.
So good afternoon, Your Honor.
Supposedly, this is it.
I want to start with
To see if they're gonna fix it.
some of the things that were addressed over the last hour and a half. First, beginning with something Mr. Merchant referenced as it related to the comments that the state made in regards to the good faith basis in which was submitted to the court, in which defense counsel claimed the evidence would show. And I would strongly bring to the court's attention that the claims that were made were material misrepresentations. And what I will say to the court, and why I say that to the court, is because the representations that were made by counsel was that Miss Daisha Young, Miss Sonia Allen, Mr. Dexter Bonds, Investigator Hill, Investigator Green, Investigator
It's the verdict.
Ricks, all of these people would be called, and Mr. Bradley would be able to impeach their knowledge
Yeah.
by saying that he specifically in his presence or to him said that Miss Willis and Mr. Wade were in a romantic relationship and that Miss Willis and Mr. Wade were cohabitating, that they all knew that. And I would submit to the court, we didn't hear from any of those individuals. Mr. Bradley impeached no one. And I say no one because he did not impeach Mr. Wade. In order to properly impeach a witness, you have to confront the witness with the specific statements. Mr. Wade, and you can look back at the YouTube of the entire hearings of the last couple days, Mr. Wade wasn't once confronted with a statement that he claimed or said, or that is claimed that he said to Mr. Bradley. The way you properly impeach somebody, you have to confront the witness. Here would be Mr. Wade. And once he makes a statement that you believe to be inconsistent, and you have a witness who can prove that inconsistency, that's when you call that witness.
Kissing and holding hands. More people, you wasted people's time. We already know they was fooling around.
And when Mr. Wade was on the stand, not once was he asked, did you tell Mr. Bradley this in a confidential conversation in your conference room that was not covered under attorney-client privilege? That was not asked. The specifics of that conversation was not asked. So any testimony that Mr. Bradley testified to is impermissible.
What?
It is improper impeachment because they did not confront Mr. Wade with it. So that's where the state would begin with the comments that Mr. Merchant made about me referencing his wife as lying. I never called Miss Merchant a liar. I never used those words. I don't know why she made the material misrepresentations. It could be because Mr. Bradley lied to her. I don't know the reason. So, but I can submit to the court that those were material misrepresentations that were made to this court on the day a few Mondays ago, as everyone was arguing the motions to quash certain subpoenas. I'd also bring to the court's attention that during that motion to quash subpoenas, certain subpoenas, Miss Yurdy's attorney appeared, Mr. Partridge, and he made very clear on that Zoom that Miss Yurdy had absolutely no knowledge of a romantic relationship and absolutely no knowledge of cohabitation. Those were the specific references that he made. So what I would submit to the court is those are considered adoptive omissions that his client has made based on the statements he made because of the representations she made to him. So, and I know that sounds convoluted, but what I would say to the court is Miss Yurdy told Mr. Partridge, because Mr. Partridge told the court that she had absolutely no information about a romantic relationship, and she had absolutely no information as in regards to.
So, but wait, are you making an argument I should make inferences based? Now, these would be attorney-client privileges or communications then. She's communicating with Mr. Partridge about what her upcoming testimony is. That's why she's hired him. And you're telling me I should infer things based on her communications to him?
Absolutely, because they're not attorney-client communications anymore when he discloses them to the court and everybody else as they watch the Zoom and attend the hearing. The difference is there was no request to go in camera. There was no request to go or to have a private conversation with you as was done with Mr. Bradley. That would have been the proper procedure. So yes, I'm asking you to infer that 100%. I'm asking you to infer that her testimony was at best inconsistent. Because the testimony of Miss Yurdy, when she testified, was vague, very little description when asked in a very leading manner. Is it true or do you know that Miss Willis and Mr. Wade were in a relationship from 2019 into
they
the
were
time
doing
you
the
were
bang
fired,
bang
or,
boogie.
excuse me, you were forced to resign from the district attorney's office in March of 2022? She said yes. And then further, when pressed by Mr. Sadow, he talks about why she believed they were in a relationship. And what was interesting from Miss Yurdy's testimony, that they were pretty close friends up until she left the DA's office, that she asserted to the court that on a yearly basis, Miss Willis said, I'm in a relationship with Mr. Wade in 2019. Oh, by the way, I want to tell you again in 2020, because we're in a new year, I'm still in a relationship with Mr. Wade. And again, in 2021, the assertion is Miss Willis then went back to Miss Yurdy and confirmed, hey, I just want to reconfirm me and Mr. Wade are still in a relationship. It's absurd. It's absolutely absurd.
Yeah.
More importantly, when Mr. Sadow asked her about why she believed that they were in a romantic relationship based on her own observations, she said something. He actually asked her, did you see him kissing or hugging? She said yes, but there was no description or qualification about when it occurred, what she actually saw. Was it a kiss on the cheek? Things of that nature. So I would ask you to frame her testimony from that standpoint when you're addressing her credibility, as the court is going to do with each and every witness that you heard during the testimony of all the witnesses during the hearing. I'm going to see if my screen will share.
Oh, Fani was like, you better get me off this or you won't have a job. Look at her, she like, is this gonna work? Are they buying this?
Now, I want to talk a little bit about the standard and the burden here in this instance as it relates to defense counsel and the claims that they have made in the motion to disqualify. And as I was doing a whole lot of research, I came upon this law review article from Cornell scholarship reading or publication. And they made very clear that courts have been relatively reluctant to exercise their power to disqualify prosecutors for any reason. And that goes along with the standard. What the state would submit to the court is that the defense has to show an actual conflict. And in this instance, they have to show the actual conflict would be that Miss Willis received a financial benefit or gain.
They showed it, all the trips.
Or got it based upon the outcome of the case. It doesn't make any sense. It makes absolutely no sense. And during the 3 days of the extensive testimony of all of the witnesses and the prolonged examinations of the witnesses by multiple defense counsel, they still got nowhere. We're in the same position we were in on Monday. The same assertions that were made on Monday have no answers today as we're before Your Honor.
Yeah.
They were not able to provide any evidence as to, or to the contrary of Miss Willis and Miss Wade's assertions of when their relationship began. There's absolutely no evidence that contradicts that the relationship did not begin later than
text messages
around
that showed that his car was over there, that he came over after they had some late night texts. He was there at midnight, left at 4 something in the morning. This is the proof right there, dude. What are you talking about? You need to be quiet.
March of 2022, Your Honor. I'd further submit to the court because of this failure that their assertion or their request that one, the indictment be dismissed. There's absolutely no evidence that the defendants in this case, their due process rights have been harmed in absolutely any way. There was zero evidence, not a single shred of evidence was produced through any of the exhibits or the witness testimony showing how their constitutional rights, their due process rights were at all affected by the relationship that began in March of 2022 with Miss Willis and Mr. Wade. And because of that, the motion to disqualify should be denied. And Miss Willis, as the district attorney of Fulton County, and Mr. Wade, as the special prosecutor assigned to this case, should be allowed to remain on this case and continue to prosecute the case to the end, Your Honor, until the trial is set by the court and is to begin. Now, the issues, obviously, you've heard a lot from defense counsel as to what the issues are for you to, I guess, determine. And here it would be the state's contention is that you must find that there's an actual conflict if you were or are to come to the conclusion that you should disqualify Miss Willis and the district attorney's office.
Right.
And looking at
Absolutely correct.
what
I think you're talking about Mrs. Ventura.
it's McGlynn v. State, McGlynn v. State, 342 Georgia Appeal 170. It's a 2017 case. In that case, as it talks about the standard of proof that the defense, or the burden that the defense must show and go to show an actual conflict, is they say it's a high standard of proof, which is definitely not a preponderance of the evidence, which is a much lower burden for any party who's trying to meet that standard of preponderance. But it's clear that the standard is that is a high standard of proof for both when determining whether there's an actual conflict and when there's forensic misconduct that is found, Your Honor.
Gotcha.
And I want to go through some of the cases that defense counsel has referenced as they argued here today and in their filings. And
Just say
I guess
it.
the bright line standard, or the standard and the grounds for which disqualification
Yeah.
is appropriate for Your Honor to be determining in all of the cases as it relates to disqualifying the
And her last
elected
too.
district attorney is you either find that there's a conflict of interest or that there's been some sort of forensic misconduct. Those
They
are,
showed it, proved
I guess, the
it.
two areas that Your Honor, that is in your purview when you are looking to resolve an issue.
When she puffed up his payments, was paying him all that money for some work that he's not even qualified to do, wasn't even in his line of work, and them going on these elaborate vacations and stuff. That's the benefit.
Regarding disqualification. Now, in a recent case, Levy State, which is 224 Georgia, Lexus 31. It's a February of 2024 case here out of our appellate courts. And in that case, Justice Pinson wrote that a trial court did not abuse its discretion by failing to disqualify an assistant district attorney absent an actual conflict of interest. And that is the case that was ruled on by the Georgia Court of Appeals about a month ago, Your Honor. Now, the cases in which defense counsel has relied on in their briefs and here today, I would submit to the court, the cites are misleading, are inapplicable, and some of them actually support the state's position.
Wow.
And what I would say to you is that the defendants, in many instances, combine language from the multiple cases and kind of what I would say is misstates the law as it relates to what the law or what is required in order for an elected district attorney and their office to be disqualified. And what I would submit to the court is...
Let's go back to that. Show me how.
Come on, Judge.
Show you how.
So I think the first one they cited was Battle versus the state. Certainly a conflict of interest or the appearance of impropriety would be the grounds of disqualification.
Well,
there were a number of these cases that seem to exclusively rely on the appearance of impropriety.
right.
Well, they acknowledge that there's some ambiguity here, that sometimes Whitworth gets cited to Ventura, and we've got this quote that comes up where it's just they only cite to an actual conflict that must be involved. They acknowledge the ambiguity. You're saying there's no ambiguity whatsoever.
I am saying that, and why I am saying that, why I would submit that to the court is in all of those cases, they do reference the appearance of an impropriety, but they reference that because they also find there's an actual conflict in each one of those cases.
Yeah.
So your position would be, your review of the case law, there's never been an appellate opinion that relied only on an appearance of impropriety.
As it relates to a prosecutor or district attorney, yes.
Oh,
That is what I'm saying. What I would say is in those cases, they do reference the fact that there is an appearance of impropriety, but they reference that fact because when you have an actual conflict, there's always an an appearance of impropriety. And those are what those cases stand for. And I guess that is the main example of what I reference as they kind of combine
Look at
the
the
language in
face.
separate and different cases and tell you that the standard is an appearance of impropriety. And I would submit to the court that is not the standard. And in my first reading, like Your Honor, I did notice that the cases each reference the appearance of impropriety, but also that appearance arose from the fact that the court found an actual conflict in each one of those cases. So I won't belabor the point in going through all of the cases that the defense had cited, but what I would submit to the court and reading those cases is that I found that they kind of fell into 5 categories. That some that didn't concern disqualification at all, some that determined or that were about, I call it divided loyalty, which is a conflict that arises from representing becoming a prosecutor and then having represented the defendant prior to becoming a prosecutor, and then whether there's an actual personal interest in the outcome. And then others talk about whether the defendant was denied a fundamentally fair trial at the conclusion and of the case after conviction. And these are some of the cases that defense counsel had cited within their brief that had absolutely no application to the issue that we're here before Your Honor today. The first, McIver v. State, has nothing to do or has nothing related to the disqualification of anyone.
And I think some of these are just relating to kind of aspiring for broad language about standards to prosecutors. So point taken there. But if they're more, all right, keep going.
Yeah.
So as it relates to one of the cases that was referenced here earlier and is also referenced in some of the briefing by defense counsel is the Regested v. State, which is 287 Georgia 542. And all of the cases that fall under this, what I would call category, is about a attorney who formerly prosecuted a defendant in I guess the same type of case or the same case or similar charges. And that would be why the courts found that disqualification would be necessary because of the relationship that existed between the former client and the now person who's being prosecuted, Your Honor. The next series of slides just goes through what has been addressed as it relates to the standard that is required when dealing with the issue of disqualification. And the state would contend and submit to the court that the defense must show an actual conflict in order to have the district attorney disqualified. And that actual conflict has to be in the form of showing that Ms. Willis, in this instance, received a financial benefit or gain in relation to the outcome of the case. Like many of the cases that involve personal interest, Your Honor, it's all based on a contingency fee, where
riding that deep,
how much they're paid, or a bonus, for example, is dependent upon the outcome of the case. That's how one is to show that there's a personal interest in the case. We have none of that here. And I would submit to the court, we have absolutely no evidence that Ms. Willis received any financial gain or benefit. The testimony was that Ms. Willis paid all of the money back in cash as related to the trips. And if didn't pay back in cash, it was
all right. Let me explore this one a little bit. So, in addition to you're saying it's only an actual conflict. Are you also saying that it's only if a financial interest is affecting the final result, the outcome? That's the only one we should be worried about? Or is it that the prosecution as a whole is what we should be looking at in terms of a stake? So what I'm thinking of, I'm just going to try and come up with some hypos here. What if ADAs are given a bonus for every motion to suppress they win, $1,000 per Fourth Amendment claim they win? Well, now they've got an incentive, if one of their officers is lying, not to tell you about it, because they want to win that motion to suppress. But maybe that doesn't affect the outcome, because you can win a motion to suppress or lose it, and that doesn't decide whether, it's going to be a guilty or not guilty verdict. But doesn't that affect the prosecution of the case, if not the outcome?
Yes, I would definitely agree that would be an instance where disqualification would be necessary and appropriate, because it's a situation that involves a contingency fee. And I would submit to the court that it actually does end up affecting.
It could, based on how important the motion to suppress is, right? But if it's some immaterial, I don't know. But I guess, so you're saying it's maybe not so much just whether it's a guilty or not guilty dismissal, no pros at the end of the day. It is actually the conduct of the prosecution that should be looked at throughout the course of the prosecution.
Correct, as it relates to how it affects the prosecution, which I would submit to the court ultimately is going to affect the end outcome of the case. If you have a contingency fee based on winning, or how, if you win a motion to suppress, and
but that's a distraction, because this is about if they violated the laws by not disclosing their relationship. They're trying to distract us with this here, which is not what the whole thing is about.
If you win, you get a bonus, as Your Honor referenced. I think that is ultimately going to affect the end outcome of the case, because, as Your Honor just said, if there's an instance where an officer's lying, or where there isn't a good faith to go forward with that motion, the prosecutor would go forward with regardless, because of the contingency fee, which not only affects the prosecution at that point of the proceedings, but ultimately is going to affect the entire case. Because if they were to win a motion to suppress, or I guess the motion would be denied and the evidence wasn't suppressed, knowing that they didn't have a good faith basis to go forward affects the ultimate outcome of the case. So I think it's twofold, as Your Honor has referenced. I think it's at that part of the procedure of the proceedings would definitely qualify for a reason necessary to disqualify a prosecuting agency. But ultimately, that action during the procedure will lead to the ultimate outcome of the case being or hinging upon a contingency fee like the ones in the cases referenced by counsel and the state that are on the screen.
So getting into the language again, what you just had up there with greater amusements and amusement sales. Greater amusements is one of those. You refer to the appearance of conflict as dicta. Why do you think that's dictated? I think the quote from that one is, it guarantees at least the appearance of a conflict of interest. Why is that dicta? It seems very central to the holding in the case.
Because I don't disagree with Your Honor, but in that case, an actual conflict was found, and the appearance.
They didn't find that.
I would disagree with Your Honor. My reading of the case is that an actual conflict was found, but because of that actual conflict, an appearance of impropriety was seen. And that's the reference, or why the state referenced that case in relation to the argument that an actual conflict is required.
And we found the actual conflict.
In the series of cases, Young, that was referenced by defense counsel, as well as Nichols, these state are both instances where there's a personal interest in the case due to the situation and where at one point they were opposing parties. And of course, there's a personal interest or stake as it relates to prosecuting an opposing party in a civil claim, which are what both of those cases reference, which shows that there's an actual conflict of interest that relates to the personal gain of the specific prosecuting agency.
And what do you make of Nichols' reference to, it's an older case. Sometimes the language can be what we're not accustomed to seeing, but there's, they refer to the metaphor of Caesar's wife. And generally when that's used as a ethical standard, that's something that goes beyond just an actual conflict, right? Isn't the beyond reproach getting more into appearance world?
Is it getting beyond?
No, isn't getting into the appearance aspect of things when we're talking about Caesar's wife.
But I think it goes beyond that based on the language of the holding in that case, where it literally says that the individual had a personal interest in obtaining a fee by forcing a settlement in the civil case and using the criminal case as leverage. So that's not an appearance of impropriety. That is an actual conflict of interest in which arises because of the individual's personal stake in the end outcome
And
of
her
the case.
personal
Your
stake,
Honor.
what
So
she was going to
that's how I would
gain
differentiate.
by doing this case.
I guess the representations of defense counsel as it relates to the standard or the burden that must be shown, and why the state would submit to the court, and the most recent ruling out of the Georgia appellate courts that an actual conflict is required to be shown. So I'm going to skip through these series of slides.
Thank you.
You've heard all about Whitworth.
Uh-oh.
So I go back to what we referenced earlier, what's been referenced by all parties, that the grounds in which a district attorney can be disqualified is where a conflict of interest is found, and where there's forensic misconduct that is found. Those are the two grounds that are to be, I guess, are within the purview of the court as it relates to the issues here. And again, I go back to the most recent case that was Justice Pinson wrote about, and that it must be that by failing to disqualify the assistant district attorney absent an actual conflict of interest. I think the language there is very clear, and I think it's very controlling, and I think it's purposeful. I would submit to the court, because an actual conflict of interest is what is required in order for a district attorney to be disqualified, because the cases make very clear, and through the precedent relating to this issue, that a disqualification of a district attorney is the last, for lack of better words, ditch effort that should be exercised as it relates to the court in curing certain conflicts that may arise. I think the case law is very clear that every effort is supposed to be made instead of, or I guess in lieu of, disqualifying the district attorney unless an actual conflict of interest is what's found, Your Honor. And it can't be cured. So what I would reference to the court, as was brought up earlier in Lyons v. State, 271, Georgia, 639, a 1999 case where it talks about a theoretical or speculative conflict will not impugn a conviction, meaning that speculation, conjecture, things of that nature, assumptions are not enough for anything to arise to an actual conflict. And what I would submit to the court as well, that goes to the fact that what it has to be shown is an actual conflict. If it's speculation.
Is there any qualifier there, though, that's in a post-conviction context?
Thank you.
So we're talking about, competent evidence. We're obviously in a pretrial phase here. I've wondered how much import to give that sentence when we're in a pretrial realm. That's assessing whether to overturn a conviction, and usually that's kind of an entirely different standard where we assess as a totality: was there a fair trial? Is there harmless error? I know there's no harmless error when it comes to disqualifications, but just a thought. If you have any reactions.
Well, I think what Your Honor said is pretty.
You're trying to help them.
On point, in the sense that if it's found that if the trial court either applied the wrong standard or should have disqualified the district attorney, it leads to an automatic reversal, like you said, and it goes back to the trial court. And I think that is very enlightening in the sense that that's only done if an actual conflict is shown, and the fact that it can't just be theoretical, speculative, or assumptions that would lead to the appearance of impropriety, the appearance of a conflict that would lead to.
You feeling confident?
I guess what I'm borrowing kind of from, as we've been doing the other pretrial motions, special demurrers seem to get different treatment pre-trial and post-trial. Post-trial, they get more of a pass unless you can show some issues. And I'm wondering if that same principle applies here with disqualification.
Well, and
But I don't have the answer to that.
well, what I would also say, and I don't remember the exact line, but I know there in Judge McBurney's order, he does address some of the concerns as it relates to the standard as it is applied post-conviction versus pretrial during pretrial issues. And what I would say to the court is that.
So you're citing that in support? Because I didn't think the state was all that pleased with the analysis he applied.
Well, what I'm citing.
Legal analysis, that is.
I'm citing what you specifically referenced as to the standard that is to be applied pre-trial and post-trial, whether it makes a difference. And what I would say to the court is the answer is no, as it relates to the speculative nature of the allegations or the claims made by defense counsel as it relates to whether a conflict actually exists, Your Honor. Examinations of the witness. What I can't do at the moment is point exactly to the page at the end of the state's argument. I can give you the page number as it relates to Judge McBurney's order.
I think I know what you're talking about. The footnote where he references the appearance standard.
Yes.
All right.
Right.
I'm looking at it.
Further, in Lamb v. State, 267 Georgia 41, on page 42, it's a 1996 case where the court says, nevertheless, the conflict must be palpable and have a substantial basis in fact. A theoretical or speculative conflict will not impugn a conviction which is supported by competent evidence. Now, I understand as it relates to the post-conviction factor or the status of the case being in post-conviction based on Your Honor's earlier inquiry, but I would submit to the court that as it relates to the issue of disqualification, that the standard is the same, whether it's post-conviction or pretrial. In Bloomfield v. Bornstein, which is 247 Georgia 406, the 1981 case. In that case, it says the appellees have not shown us a case where a per se rule was applied to disqualify an attorney on the basis of an appearance of impropriety alone. Georgia cases cited by the appellee do not stand for the proposition that a trial judge is authorized in Georgia to disqualify an attorney solely on the basis of an appearance of propriety, which further goes to the state's submission to the court that the standard is that
Well, what about the perjury?
actual conflict must be shown, and that conflict that arises shows that there's a personal stake of the district attorney as it relates to their personal financial gain that's being alleged. So in the case that's been referenced by all parties here today, Whitworth v. State 275 Georgia, Appeal 790 to the 2005 case. In that case, it says Whitworth's complaints are largely based on speculation and conjecture. Applying any evidence standard to the record, it is clear that the trial court did not abuse its discretion in denying Whitworth's motion to disqualify Morgan based upon his personal interest in his conviction.
Aren't we past the speculation and conjecture aspect of this, though? I mean, the original and the core of the financial allegation was that there is a relationship and that money has changed hands. There's maybe still an open question of where the ledger stands, but I think it was conceded that that balance could run in one way or in the district attorney's favor. Is that contested?
Yes. What's not contested is that a relationship did develop between
and that purchases were made back and forth. That's the state's position.
That is the state's position, but they were made back and forth. The purchases were made back and forth, either to equal the money that was spent by one party or the other, and if that wasn't done, cash was exchanged in order to equal the costs that were paid by either one of the parties.
Right, but that's a facted issue, whether it was split even or whether it goes a little bit one way or another, or whether it's all the way $10,000 one way or another. That's a fact and issue as a result of the hearing, but it's no longer just the theory that money changed hand is no longer speculation or conjecture.
Well, I agree that money actually changed hands is not
There we go.
speculation and conjecture, but whether that money that changed hands had any financial benefit or gain to the district attorney, that is all speculation and conjecture. I would submit to the court. Absolutely all speculation and conjecture to harass and honestly embarrass the district attorney based on some of the questions that were asked that had absolutely nothing to do with the proceedings that we were here. For example, the lien on her alleged house, that was highly irrelevant, had nothing to do with the proceedings and the exchange of money between the district attorney.
If she had all this money, why didn't she pay her taxes? She's the DA. It is relevant. It goes to prove that she didn't have all these bags of cash hanging around where she can just go into her magic bag of cash and pull out $3,000, $4,000, and $5,000 to give to Mr. Wade.
And Mr. Wade, the point of that line of questioning was to, again, embarrass and harass the district attorney in a way that was very public, and in a way that was to impugn her character
because
as it relates
black,
to
right?
that line of questioning in front of the court, in front of anyone watching the proceedings as it unfolds. And the language in Whitworth, I would again submit to the court, requires that an actual conflict must be shown, which is why the reference to speculation and conjecture is again a reference, because speculation and conjecture leads to or equals an appearance of impropriety, not necessarily an actual conflict, which I submit to the court is what is required based on the case law.
Yeah.
So in State v. Sutherland, which is 190 Georgia Appeals 606, it's a 1989 case, and it says, while the prosecuting officers should see that no unfair advantage is taken of the accused, yet he is not a judicial officer. Those who are required to exercise judicial function in the case are the judge and the jury. The public prosecutor is necessarily a partisan in the case. If we were compelled to proceed with the same circumspection as the judge and jury, there would be an end to the conviction of criminals, which goes to the premise that the appearance of impropriety is to apply to judges, not prosecutors. Because if that standard was to be applied in the manner in which the Sutherland case is referencing, then there would never be a criminal prosecution, because the state is always going to appear biased as it relates to getting justice for the victims or righting the wrong as it relates to the crimes in which the defendant is been indicted or accused of.
Tell me about this one.
So I want to move into, I guess, the evidence that Your Honor saw and heard during the last couple of days, 3 total days of testimony as it relates to the witnesses. You heard from Ms. Yurdy, who the state would contend is a disgruntled former employee. You heard from Terrence Bradley, also someone who is a disgruntled former partner. The text messages in the state's opinion show that he is vengeful. You heard from his own testimony here sitting before the court that all he did was speculate, and any information that he had and garnered and then passed on to Ms. Merchant was mere speculation. I believe he said that over and over again when asked if he had personal knowledge. My recollection is around 15 times he said he had absolutely no personal knowledge of a romantic relationship between the DA and Mr. Wade. You also heard from the special prosecutor, Mr. Wade, a former judge. You heard from the 80th governor of the state of Georgia, Roy Barnes. You heard from the first female elected district attorney of Fulton County, and you heard from her father, who was a 40-plus year practicing attorney in good standing when he left the practice of law.
Yeah, we heard all them lies.
And what I would submit to the court
especially
is that
Papa.
Miss Yurdy's testimony was nothing more than inconsistent at best, based on what I referenced to the court earlier as it relates to the representations that were made by her counsel prior to.
Are those in evidence? Would his responses during a motion to quash, which weren't subject to cross-examination by defense attorneys, weren't even part of the evidentiary record of the hearing? Again, I'm just kind of puzzled by that.
Yeah.
You didn't ask the question of Ms. Yurdy, what did you tell your attorney before coming here? And then we could have dealt with privilege issues and whatever else.
I would agree with the court. It's not in evidence, but it was a statement by an officer of this court to the court during a hearing related to her testimony and how we would proceed with her testimony in this hearing. But it's clear that what was represented as to why she would not have, I guess, be an appropriate person to testify was that she had absolutely no knowledge of the romantic relationship. That was the basis of why her counsel was saying that she shouldn't have to testify, that she shouldn't be compelled by
under
the
that
court.
theory, if accepted, where did the incentive arise between Monday and Thursday for her to completely change things around?
Yeah.
Where did the incentive arise?
So she was fighting so hard to avoid the, if we're going down that road you proposed, she was fighting to have not to come in here and testify at all. And then she comes in here and testifies. Why would she have testified the way she did if she didn't want to testify so strongly? If we're going down this road of trying to just gauge her interests and these kind of things, I don't know if I'm quite following that theory.
And I can appreciate that, but I would say the reason she didn't want to testify, I would submit to the court, is because this is an incredibly public forum where she would have to testify against a former friend and a former boss. And I think the change, I wouldn't qualify it as an incentive. What I would qualify it is ultimately when she was forced to testify, right, a motive and a bias as to why she testified in the manner in which she did. When asked by Ms. Merchant as to the reasons for her leaving, she kind of danced around the issue. And then as Ms. Cross asked her about whether she resigned or forced to leave, she was fired, she came out and said she was given the choice, you can either resign, but either way you're leaving. You're fired, or you can resign in a manner in which, she wouldn't be officially fired, when she's trying to get future employment and things of that nature. So I would submit to the court that there's absolutely no incentive. An incentive is not why Ms. Yurdy's testimony changed, or the state would contend her testimony changed. But it was the reason she testified the way she did was because of her bias towards the DA, which gave her motive to what the state would contend is be less than honest.
But then why did she not want to come in the beginning then? Dude, you kind
But if we're going to draw inferences based on her fighting the subpoena,
thank you.
Why would she have fought it if she had such a bias and wanted to say these untruths?
Yeah,
she didn't want to come on national television and have to be exposed to the things that
you can't even explain it yourself.
Well,
well,
I don't know anybody who wants to testify before a court in a normal trial, a normal proceeding, but one of what I would qualify in this high profile of a nature where everybody
in that case, she should have been
be
running to
able
get
to
there so she can tell and put it down, set the record straight.
Watch and learn at what she has to say as it unfolds in the courtroom. And I'd further submit to the court, there is reference to she left the DA's office in the text message that were submitted in, I believe, Defense Exhibit 39, that it's because she released confidential information in the DA's office, from the DA's office, that led to her firing, that she wasn't.
And I know I'm just because it's more conversational, which I appreciate. I know I might be getting you off script, so I don't want to use up all your time if you need to get through some other things.
Next, Terrence Bradley. And I believe the one thing that the state and defense counsel can agree on, that he was less than honest at times during the proceeding and during his testimony. He, when pressed or asked by Mr. Sadow why he was fired, he basically chalked it up to a dispute between partners in a business. But when pressed by Ms. Cross, it was clear that that wasn't the reason. And what I would submit to the court, what has been referenced by defense counsel as baffling as to why the state would go into such a topic area. The state, as all counsel has when appearing before the court, has a duty of candor. And when Ms. Cross knew she was going to have to cross Mr. Bradley, she knew he lied. And she had a duty of candor to the court, in the state's opinion, to expose that. More importantly, it goes to his credibility and the statements that had been represented by defense counsel that he allegedly had made in the past. So it was important to bring that to the court's attention, because when a witness is testifying, the court is assessing their credibility and determine to whether to believe the veracity of the statements made by the witness or not. So that is the most important factor when determining whether somebody is telling the truth or a lie. Furthermore, he reluctantly, when pressed, finally admitted that he paid off the assault victim. Eventually it started with an escrow account and led to he did pay off the victim in that case.
All of that.
He testified over a span of 3 days, and like I referenced to the court, he must have said 15 times that he had no personal firsthand knowledge as it relates to the relationship between Ms. Willis and Mr. Wade. More importantly, when pressed by counsel, he could not pinpoint a time in which he knew that the relationship occurred. There were many instances in which he described that very well could have fallen within the time frame that was testified and by both Ms. Willis and Mr. Wade, as it relates to the relationship beginning or transitioning into dating in March of 2022 and into
which was lies.
The end of the relationship in August or the summer of 2023. And as I referenced to the court, the statements that Mr. Bradley made, the state would contend are inadmissible hearsay as it relates to the statements that he was pressed and asked about what Mr. Wade told him, because Mr. Wade was never confronted with those statements. And in order for impeachment to be proper, he must be confronted with the specific statements that are alleged to have been made in order to impeach him. Again, Mr. Bradley had every motive to lie. I believe the text messages are kind of clear, are very clear as it relates to his disdain towards Mr. Wade, which due to the fact that, he was expelled or exiled from a thriving law practice. And it was clear that the practice and Mr. Wade sided with the alleged sexual assault victim, which is clear. He assaulted her due to the fact that he paid her off. And as I referenced earlier, Ms. Merchant represented to the court that Mr. Bradley had personal firsthand knowledge basically of it all, of everything, and that he would be able to basically be an impeaching machine. I think Your Honor referenced him as the star witness when you were addressing the claims that were made by Ms. Cross in relations to Ms. Merchant's representations to the court. And what I would submit to the court is that all Mr. Bradley's representations as it relates to when the relationship between Ms. Willis and Mr. Wade began, and whether they cohabitated, because that was a promise that was also made, that he would be able to impeach the investigators as it relates to cohabitation, was mere speculation, gossip, and innuendo.
But the text message
and this is, Your Honor.
The impression I got, and we can correct this while we're all here together, is that Mr. Bradley directly overheard a statement from each of these individuals that they could be impeached with. Ms. Merchant, is that accurate?
Directly overheard. Which ones are we talking about?
Well, essentially, that kind of seemed to be
All of them. You had said Allen, Bond, Young, and then the investigators, Hill, Green, and Ricks, could all be directly impeached by statements overheard by Mr. Bradley.
Yes.
In reference to your question, the unequivocal answer was yes. And when Your Honor is looking through the text messages, I would submit to the court that the text messages don't even say or indicate what was represented to the court in relation to the good faith basis for this motion to disqualify as it relates to the testimony of and the ability to impeach witnesses through Mr. Bradley. What's been referenced by all counsel is Mr. Bradley's assertion of absolutely as it relates to whether the relationship existed prior to Mr. Wade's hiring. And the question in itself involves speculation because it asks, do you think it started before she hired him? And he says, absolutely. He doesn't say he knows. He doesn't provide any context as to how he knows. And in these text messages and through his testimony with the court, the source of his information was unclear. What I would say to the court as to a lot of things, other than the one conversation that allegedly occurred between Mr. Wade and Mr. Bradley. And I would submit to the court that conversation never occurred. That would be the state's contention. And how do we know that? We know that because that conversation was not confronted, or Mr. Wade was not confronted with that conversation. And that
because he testified first.
Circumstantially, and I'd even say direct as to that conversation not existing. Because based on the representation made by defense counsel, it would be clear that that would be a conversation that would have been relayed to, because it wasn't privileged, as Your Honor found, that would have been relayed to Ms. Merchant. And if that conversation happened, you better believe that would have been a conversation that defense counsel would have confronted Mr. Wade with and against. And the reason they didn't do that was because it didn't exist. Again, you heard from Mr. John C. Floyd III, the district attorney's father. As Your Honor heard, he was a well-respected member of the legal community for over 40 years. But the importance of his testimony was to provide the court with corroboration as it relates to the years leading up to the relationship that transitioned into dating between the district attorney and Mr. Wade. What he testified to is that he moved into her South Fulton home in 2019. The evidence of his moving into that home at that time was his Georgia driver's license, official government document. He further testified that not only did it wasn't that just Miss Willis and himself live at the South Fulton home, but that he often would see on numerous occasions the significant other of Miss Willis that was not Mr. Wade. He referenced that that person had a nickname of Deuce, and that he kept a lot of his belongings in the garage of Miss Willis. He specifically said he kept a lot of his disc jockey equipment, is how he referred to it when before the court. He made very clear that he had never seen Mr. Wade at the South.
They were having an affair. Those are you
owned by Miss Willis. He made clear that he lived in that home with Miss Willis and Miss Willis alone, other than her two daughters who would occasionally visit that home until after February of 2021. But what precipitated the soon move of Miss Willis to what I would reference as safe houses for her protection was a protest that occurred before her home in February of 2021. He then expressed to the court that Miss Willis moved in the spring of 2021, and that due to these threats that were taken very seriously, he had only seen his child 13 times. He said, in reference to the questions by defense counsel that were in a, and I'm just going to be straight up with the court, they were trying to make Ms. Willis a liar, what is how I would submit to the court, in the sense that she testified that she was concerned for her safety and her family's safety, which included her father and her daughters, and that Mr. Floyd remaining in that home kind of rebutted all of that, made it so it wasn't true. But he testified that he stayed in the home because it was a home that she had put her blood, sweat, and tears in and was able to buy, and that he stayed in the home because there was constant officer presence. He told the court that he bought extra security equipment. He even went as far to tell the court that he slept in different rooms on different nights because he felt his safety was in such a concern. So I would submit to the court that line of questioning was done in an attempt to discredit Ms. Willis, but failed. Would be what the state would characterize it. Then he testified about the first time that he did meet Mr. Wade, which is in 2023 here at the district attorney's office. And he talked about how he kept cash in his home and why Ms. Willis kept cash in his home. And what I would, what the court should take note of is the state didn't ask Mr. Floyd about the cash in his home. That came out
because
the cross-examination.
She told her daddy to say that. That's part of the story. This explains why she was able to give Mr. Wade all this cash that's unaccounted for, is because her daddy told her to keep cash.
Of defense counsel.
So
there was I guess the implication that Mr. Floyd only did so due through his preparation with the state and his hearing and seeing news articles and clips related to the testimony that had occurred prior to him.
Exactly.
But I would submit to the court that it's telling that that information came out through questions that were asked by defense counsel, which gives credibility to the statements that were made. And he further explained as to why he taught his daughter to keep cash in the home as it relates to financial independence and having.
Well, then she should be guilty of tax evasion. Then, if you giving away all this cash, but you haven't paid your taxes, and then you just admitted that you had the cash, that's tax evasion. So she's like, come on now, pick one.
Being a safety net. It was further testified that he had multiple safes and that he gave Miss Willis his first lockbox or her first lockbox for situations as she described when she was testifying. And what I want to make clear is during Miss Willis's testimony, it was pressed about the cash and where she kept it. Did it follow her, where she laid her head and things of that nature, trying to further discredit the practice that she had as it relates to keeping cash in her home and why she had the ability to pay cash to Mr. Wade and other people and for other situations. And what the court should take note of is that there was no evidence that controverted that at all. Where was the evidence that controverted Miss Willis's claim and practice of keeping cash in her home? There was none. In fact, the only evidence it was substantiated through the testimony of her father, Mr. Floyd.
I know it wasn't.
Furthermore, you heard from former Governor Roy Barnes, and his testimony was significant and important because how I would phrase it, Your Honor, is it debunks.
Let me on this point, and I think you might have had a more recent opportunity to review his testimony than I have. You say on the slide that she was the first choice to lead the prosecution. Was that actually his testimony, or was his testimony that he was asked to come aboard? Did he use the words that he was asked to lead?
Yes, it would be that's my recollection, that he was asked to lead the prosecution. He was asked to he was asked to fill the position that Mr. Wade is currently in, which is the lead prosecutor. It was said in that way as well as it relates to the testimony of Mr. Barnes. So I think it would be very clear. My recollection is that he said lead, but what I can submit to the court that I know he also said that he was asked to fill the position that Mr. Wade is currently filling for the state of Georgia, which is the lead prosecutor.
At that time as special grand jury prosecutor, right?
Yeah, the special, I guess, yeah, as the special prosecutor lead the investigation, which led to the ultimate prosecution that we're here before Your Honor today. He also indicated that the reason he turned that job down was because it didn't pay enough. He said he had mouths to feed at his law firm, and that he also didn't want to live the rest of his life with bodyguards because he had lived that for the years in which he was the governor of Georgia.
Wow.
Furthermore, he confirmed the qualifications of Mr. Wade, which I still find it quite interesting and confusing as to attacking Mr. Wade's qualifications, in that it's almost as if Mr. Roman's counsel is asking that the state put a prosecutor on the case that she sees to be more qualified to attempt to convict her client. It's an interesting argument, and it's one that makes no sense. Furthermore, if you were to believe the claims and allegations as it relates to Ms. Willis' personal stake in the prosecution, the receiving of financial benefits and gains, then you'd have to believe that she was also dating Roy Barnes, the former governor, and Gabe Banks, in addition to Mr. Wade. If she has this grand plan scheme in order to profit off of the prosecution of this case, because that's what they're saying. Or they're saying that she telepathically or prophetically was able to know that Mr. Barnes and Mr. Banks would turn down the position so she could then hire Mr. Wade. It's ridiculous. It's absurd, and it's desperate. It's a desperate attempt to remove a prosecutor from a case for absolutely no reason, Your Honor, other than harassment and embarrassment. This slide, and we've been through a lot of the testimony.
And I should be clear there, it was not introduced in evidence that Mr. Banks turned her down, right? How's that part of the record?
Well, I'd ask the court to take judicial notices, has been asked repeatedly.
Unless the district attorney testified to that. I don't recall offhand.
I will be frank with the court. I don't recall if Ms. Willis testified to that exact fact, but I know that Mr. Banks represented that to the court during Monday's hearing as it relates to the allegations that were made. I understand Your Honor's position as it relates to that.
Trying to make sure we know exactly what is in the evidence and is not, but regardless, I think your point is made.
I think it's an evidence of the record as it relates to, I guess, the issues that led up to the actual hearing of this case. So I understand Your Honor's position, but it did come out during a proceeding that was prior to the actual hearing. This slide is just a chart showing kind of the testimony of both the district attorney, Ms. Willis, and Mr. Wade, as it relates to how they met, how or when Mr. Wade became the special prosecutor, when their relationship evolved into a romantic one, talking about the trips in which they took after their relationship evolved into one that became romantic, and when it ended. And what, again, I would submit to the court is that those facts were consistent, and the only person who contradicted that when the relationship started was Ms. Yurdy. And what I would bring to the court's attention is that it was represented to the court that Ms. Yurdy was a witness other than Mr. Bradley who could bring to the forefront this issue of cohabitation. And when pressed and when asked about it, Ms. Yurdy had absolutely no information as it relates to this alleged cohabitation. It was false. She said she had no information. She was asked about trips. She said she had no information about the trips. Yet, she's such a good friend that Ms. Willis confirmed each year that Mr. Wade and her continue to be in a relationship 2019, 2020, 2021, until their relationship ended due to her forced resignation and it's splintering of their friendship, Your Honor. I guess several exhibits obviously were tendered in. Most of them were exhibits that came from the sealed divorce of Mr. Wade and Ms. Jocelyn Wade, contracts for legal services, trip itineraries, and the text messages. And I would specifically reference prior to today, the only text messages that were before your honor were defense exhibits 26 and 27, which it's the assertion of defense counsel that what those show is that Mr. Bradley had information as it relates to the relationship starting prior to March of 2022, and that's just false. Those text messages do not contain that. It does not pinpoint, just as Mr. Bradley couldn't, when the relationship actually started. And furthermore, you have the testimony and the evidence of the text messages that it was mere speculation. If you, as your honor reviews the full chain of text messages, it is clearly Ms. Merchant and Mr. Bradley going through what I can describe as nothing else other than a mere fishing expedition between the two of them at first, because it's asked about certain members of the DA's office who would have information as it relates just specifically for one, Ms. Young. It is asked whether she would have information, and he had no idea. He said he assumed, he was speculating. And that is the same as each person that was subpoenaed in reference in the text messages. All of that was speculation. And you know it was speculation because not a single one of them testified. That's telling. Because if it wasn't mere speculation, if it wasn't mere gossip, and if it wasn't mere conjecture, each one of those people who were subpoenaed would have been called to testify, like District Attorney Willis was, like Mr. Wade was, in order to be confronted and then impeached by Mr. Bradley. You've heard obviously about the phone records, and I have a maybe because whether it comes into the purview of your honor as it relates to the determination your honor is to make as it relates to the disqualification of the district attorney. You also have the affidavit from the employee who worked at the winery who confirmed that Ms. Willis did in fact pay in cash up to more than $400. And
Wow.
I understand that this is part of the proffer of the state, but it's important because that is a witness who the state didn't go find. That is a witness who went to CNN in order to confirm what Ms. Willis testified to, further giving her statements credibility and credence before the court.
And let them know that she paid with cash. Yeah, right.
You heard about
well, before we move on from that one, other than the foundational concerns, would you have a response to the proffer of the cell phone records?
I have, I'll get to that now. I was going to get to it later, but I have several foundational concerns as it relates to the cell phone records. I don't think I've ever, as Mr. Sadow's motion makes very clear, the state uses cell phone records routinely. And I would agree with that. We use them routinely, but we use them with an expert, and they're always challenged.
Right. So, like I said, in the interest of time, setting aside the foundational concerns.
Oh, I thought you were asking about them.
No. Focusing on the substance of them, assuming that it would be admissible in the guise that he's proffered. Maybe you have that further up, but what's the reaction to that?
So what I would say initially is that due to the fact that they were analyzed by someone who was a non-expert, the analyzation of those cell phone records were not properly peer reviewed. They were not, it's clear from the state's review that the normal practices that are used to check the use of which kind of data is being used in reference to the two specific dates. I believe it's September 10th and 11th and November 29th and 30th. The affidavit that is used to say that Mr. Wade remains at Ms. Willis's or in the area of Hateville, because again, during the hearing, the address for the Yurdy condo never came out. It was just that it was the Hateville condo. The actual phone number for Mr. Wade was never established. And the documents that were provided to the state that were certified business records did not have a subscriber page. So we have no idea that the number belongs to Mr. Wade. Now I understand Your Honor wants to look past the foundational issues, and I can appreciate that. But the foundational stuff is very important as it relates to the admissibility of the records.
No doubt about that. But if somewhere how they were able to survive those foundational concerns, do you have any reaction?
Yes.
Yes,
What is it?
do, and I will skip forward so I don't.
You
So-
got nothing.
What's interesting is that the records that were provided they start in January of 2021 and they go, I believe it's to November 30th, I think is what of 2021, the span of the records. And you heard from all of the witnesses, including Ms. Yurdy, that Ms. Willis did not move into the Hateville address until April of 2021. That was the testimony from all of the witnesses, April of 2021, and that she lived in her South Fulton home from when she met Mr. Wade in October of 2019 up until when she had to move. And the assertion by defense counsel is that Mr. Wade and Ms. Willis began a relationship right after they met in October of 2019. What's interesting and what's telling is that Mr. Wade's handset doesn't once appear in anywhere near the area of her South Fulton home, but they're dating, but they're in a serious relationship. And if you were to believe what the defense counsel says, that they have been in a relationship from October of 2019 up until she moves in April of 2021. So, a year and a half or so, but he never once enters the area of her home. But they want you to believe that that's a lie, which is why counsel for defense continued to press District Attorney Willis and Mr. Wade as to whether he had ever been to that South Fulton home. Well, this corroborates that that was not a lie, that he had never been to that home. And it's more than suspect that he's been in a relationship.
If you said they only had the records from 2021, so if they met in 19, see, they're trying to distract with this little wordplay here.
As they claim for all this time, but never once went to the house. So I think that's telling. What I would also bring to the court's attention in the state's initial review of the records, that from January of 2021 to March of 2021, those times when Ms. Willis did not live again at the Hateville address, she didn't move there until April of 2021, that his handset appears in that area 23 times.
Sure.
Why
How
she's
do
not
you
living.
reconcile that with this testimony that was alluded to, I think, by opposing counsel, the reasons he gave for being in the area?
Yeah.
Well,
Would those line up to 23 times? I think,
Well,
it didn't give you too many reasons for being there, right?
I think that's the point. I would say yes, that is the point.
Look at her.
He referenced that that's an area that it was not uncommon for him to be in. And clearly that is the case because Ms. Willis didn't live in that area. So again, it's further corroboration as to what Mr. Wade indicated to the court. And after Ms. Willis moved into the condo in April of 2021, they appeared 35 times. Now, I want to make clear to the court, both Ms. Willis and Mr. Wade never denied that he had been to that condo before. The specific testimony that was elicited by Ms. Willis and Mr. Wade was that he had never laid his head, was the direct quote.
Because he was hitting it from the back.
Which these records don't prove that he laid his head anywhere. If you were to believe the analysis, or if you were to give credence to what the non-expert says as it relates to Mr. Wade's handset in September and November for the 3 to 4 hours that the phone is alleged to have remained, that doesn't disprove anything that was testified by both Mr. Wade and District Attorney Willis. It was that he visited there. The specific hours of their visits was not something that was pursued during the questioning of both of the parties. So what I would also submit to the court is that if you look at the days as it relates to in September and November, the use, the type of information that is used to make the plots for the longitude and latitude of the handset is data records. It's not voice records. It's not SMS or text messages. It's data records. And it is not uncommon for an expert to testify as it relates specifically to AT&T records that actual data record is unreliable as it relates to the location of the handset due to the type of information that it is, that it's data. It's not the voice and the SMS, which I know, Your Honor, as has been referenced, was a prosecutor not only here in this county, but for the federal government, where this kind of information is commonly used. So in the comments that were made by the court, it was clear that you understood and understand the use of cell phone records as it relates to put somebody in an area, and again, not in a specific location. I'd also bring to the court's attention as it relates to the validity of the affidavit and the analysis done by the expert that was hired by Mr. Sadow, is that not once does it reference the fact that AT&T records commonly have duplicate and triplicate entries within the call detail records. That is something that is commonly seen, and that is something that is seen in these records. And that is something that leads to the incorrect number of times that has been alleged that Ms. Willis and Mr. Wade were in communication through text and voicemail. And I'd also submit to the court that that number doesn't prove anything again, doesn't prove that anybody's in a relationship. It proves that they were in communication with each other. And I think Your Honor can use your own life experience as it relates to people you work with or friends that you're close with, and the number of times that you make calls to any of those people. I can submit to the court that I have a friend who I have been friends with for 15 years, and she worked in the office previously with me. And based on our professional relationship and our personal relationship, the friendship that we had and still have, that we talk 30 times a day. So and that doesn't mean we're in a relationship. So the assertion that the number of times that Miss Willis and Mr. Wade have spoken to each other, whether it's through text message or phone, it has no validity. As it relates to them being in a relationship. What I would submit to the court is that what was shown through all of the evidence was that there's been a true cost to Miss Willis as it relates to her life, that she had additional expenses that she had to endure because of her position, in the sense that she told the court that she had a mortgage, but on top of that mortgage, that in a house she didn't live in anymore, she had to pay for a safe house, that her home was vandalized, and there were racial epithets and sexual bigotry that were spray painted onto her house. The concern of her safety in her life is something that was testified to. And the fact that this job has led to the isolation and separation of her from her family and friends, which was given credence, and the credibility of those statements were provided by her father, Mr. Floyd, that he had only seen his daughter 13 times since all of these instances occurred. The full nature of the statements and the falsehoods that, for example, in these text messages that were purposefully leaked to the media as it relates to Miss Willis's daughter, subjecting her position in school, that she flunked out of college, which isn't true, which in fact she has graduated from an HBCU. But what's been leaked to the media is the fact that she flunked out of school and someone other than her father moved her, which again, the validity of which was never shown. And all the while, Ms. Willis, facing these costs, has been able to continue to do the work unrelated to this case, which is shown in the fact that Atlanta's murder rate and violent crime rates have decreased while she has been in office. What was shown through the testimony of all of the witnesses and through the evidence that Your Honor heard was that there wasn't an actual conflict, that the defense failed to provide any sort of actual conflict in relation to Ms. Wade's, I guess, the relationship that transpired from the relationship between her and Mr. Wade, and that there was absolutely no evidence of a financial benefit that she gained as it relates to the prosecution of this case and the ultimate outcome of the case. The corroboration of all of that is the things that Your Honor is very much aware that she could have, I guess, financially benefited from stretching out the case, for lack of better words, by the special grand jury recommended that 39 individuals be indicted. But through her sifting through the special grand jury's report and all of the evidence with the team that indicted the case, they only went with 19 of the defendants, which had she gone with all 39, they're based on the defense counsel's assertions, would have given her the opportunity to certainly find these financial gains that are claimed through the allegations of defense counsel.
Wow.
More importantly, why would Ms. Willis repeatedly ask this court to set a trial date as soon as possible if her motive in prosecuting this case was to continue to financially gain as alleged from the prosecution of this case? It doesn't line up. It doesn't make sense. And it doesn't make sense for a reason, because it doesn't exist. More importantly, this office has multiple RICO and as well as large scale cases like this one and much larger. And they also there's a lot of high profile prosecutions. If Ms. Willis's ultimate goal by hiring Mr. Wade was for her financial benefit, then she would put Mr. Wade on every single one of those cases. Though she could certainly revel in the riches and lavish lifestyle that has been referred to by defense counsel, which there's been absolutely no evidence of. The evidence was she stayed at a DoubleTree in Napa, a DoubleTree. I don't know that to be a lavish hotel. Most people, when they go to Napa, if they want to lavishly experience Napa, stay at the Ritz-Carlton, the Four Seasons, things of that nature, not a DoubleTree. So the allegations and assertions that Miss Willis was living the lifestyle of the rich and the famous is a joke, absolute joke. As it relates to what you heard, and the secondary issue is the forensic misconduct. And for lack of better words, what has to be shown is that the statements that were made by Miss Willis related to the prosecution of the case and ultimately the guilt or innocence of the defendants. And we have none of those statements. There's been no evidence. Nothing has been provided to your honor as it relates to Ms. Willis's specific statements made about any of the defendants and in relation to the guilt or innocence of any of the defendants. I forget which defense counsel referenced the fact that she said she had a 95% conviction rate. Well, what Ms. Willis's job is to instill confidence in the community as to how well she is doing as it relates to her constitutional duties. And that was exactly what was done when she referenced that she had a 95% conviction rate in the previous year that she was serving as a district attorney.
Wow.
More importantly, it's been the allegations about race and religion being imputed in her speech, and that those comments were directed at the defendants at this table. And if you listen to the speech, those comments are directed at two elected or political officials. I believe it was Marjorie Taylor Greene and Ms. Bridget Thorne, who is a member of the Fulton County Board of Commissioners here. She specifically used their names. I don't know that they, and my knowledge is they're not supposed to be sitting at the table, and I haven't seen them in my work as it relates to this case, Your Honor. So those allegations that Ms. Willis committed forensic misconduct are, again, there's no validity to them. There's no evidence of them as it relates to any of those comments, which this is an issue that Judge McBurney has previously ruled on when these same allegations were alleged as it relates to extrajudicial statements made by Ms. Willis. And it involved a statement that the words fake electors were said by Ms. Willis. And he found there was absolutely no conduct that was impermissible as it relates to forensic misconduct. And I guess to drive home the point, at no point in any of the statements that were made and that are alleged here as it relates to the speech that she made at the church, at no point did she mention the guilt or innocence of any of the defendants. She, again, was merely responding
We'll
to
have to play
comments
that
made by
video.
Marjorie Taylor Greene and Bridget Thorne to other political officials, therefore making her comments not even close in the realm of any sort of forensic misconduct. What I find interesting is that defense counsel wants to make these allegations that Ms. Willis committed this forensic misconduct by the statements that she made in her defense as two unrelated, in this case, public officials criticized the job that she was doing. And, I find the hypocrisy interesting in the sense that we've had video proffers released to the media by defense counsel, emails between counsel released to the media by defense counsel, statements have been made by defense counsel in relation to this case. We had the unredacted version of the cell phone records of Mr. Wade released to the media by defense counsel with his private and personal information causing the threat of harm to both Ms. Willis and Mr. Wade to increase.
Wow.
The most recent instance was the text messages that Your Honor hadn't ruled on their admissibility prior to their release, and it was made clear during the hearings that the ability to get those, the full chain was something that they were unable to do. But they figured a way, and the minute they figured a way, they released it, the information to the media simultaneously with turning it over to the state and the court. For all the reasons obviously stated before Your Honor, that this motion should be denied because the legal requirements that are required in order for the district attorney to be disqualified have not been satisfied.
Yes,
The
they
defendants have
have.
failed to raise any issue legally or factually to satisfy the legal standard for disqualification. They must show an actual conflict. They've been unable to show that the prosecution of this case was at all a result of political bias, which has been accused, or accusations have been made, as well as demonstrated that the prosecution of this case was motivated by any means or any way because of malicious prosecution. And they haven't been able to prove that this case was one of selective prosecution for political benefit or gain. All allegations that have been made during the course of different hearings and the procedures as it relates to this case. What I would leave the court with and how the state started the argument is that courts have been generally unreceptive, if not hostile, to attempts to disqualify prosecutors based on pervasive and institutional conflicts, which makes clear that the burden, that the standard is very, very high that must be met in order for an elected district attorney to be disqualified. And that burden, that standard has not been met. And actual conflict has not been shown. And more importantly, in conjunction with that, there's been absolutely no evidence that the district attorney has benefited financially at all, but benefited financially in conjunction with any outcome, whether it be now or ultimately as it relates to the prosecution of this case. And because of all those reasons, Your Honor, we respectfully request you deny defense counsel's motion to disqualify the elected district attorney, Ms. Fani Willis.
Good. Hey, you want to say this balloon now?
All right. Thank you, Mr. Body.
Look at her. Did our business.
That's what it says. Mr.
Wow.
Cromwell. I'll leave it. Oh, okay. Handing it over. Understood. Mr. Sadow, all yours.
Look at her. She just walk out on that part there. Still trying to make a statement.
I'm going to do rebuttal,
Good.
specific rebuttal.
I like this.
One, state somehow makes an argument that we should have asked Mr. Wade questions about his relationship and his communications with Mr. Bradley when they objected over and over and over. And Wade's counsel objected over and over and over, claiming that everything that Bradley was told by Wade was attorney-client privilege. Your Honor made determinations thereafter to Bradley. We didn't get the opportunity to call Mr. Wade back to the stand. So to claim that you can't impeach him because you didn't ask him when they objected to us asking him is obviously a false position to take. as disingenuous as it can be.
Yes.
Now, if the court wants to open it up, we'll be more than happy to call Mr.
Yeah,
Wade
bring
back
him
to the
back.
stand. But
Come on back.
as the
Mr.
record
Wade.
stands, there could be no confrontation of Mr. Wade when both his counsel and the state are arguing that it shouldn't be done.
Thank you.
Second, let's use a little common sense here.
Okay, come on.
Forensic misconduct received about 2 minutes worth of discussion. The rest of it is all on conflict. Forensic misconduct dealing with the way the state wants you to have it is if you don't accuse someone or you don't say that someone's guilty.
Yeah, assuming you can impugn someone's character to the degree that constitutes forensic misconduct. Why is that?
I'm sorry, say
Case
that.
here? Assuming you can impugn someone's character to the degree that it constitutes forensic misconduct. I think that I guess the state's primary position was that they weren't talking about you at the church.
Right. And if you go listen to it and watch it, it starts off by saying, why does Commissioner Bridget Thorne and so many others, and then it refers to they attack him for being black. They attack him, not anyone else, just they attack the black man.
What?
They're not talking about Miss Thorne or Marjorie Taylor Greene. They're talking about us. And you know how everybody knows that? Because not a single story from the media reported anything other than Fani Willis accused the defense and defendants of being racist.
Wow.
Now, here's the common sense part of this. If you follow the state's position on forensic misconduct, Fani Willis could all day long talk about race. She could say the defendants, I'm not saying they're guilty or not guilty, but they're racist.
Yep.
They're racist.
That's it.
They're racist. And according to the state's position on forensic misconduct, that wouldn't be a problem. Obviously, that makes no sense whatsoever.
Thank you.
The issue here that we've dealt with on forensic misconduct is not simply the church speech. It's why she did it, how she did it,
Yeah, so she
calculated, and all the other things that we talked about with the testimony of Wade and Willis in this case. Let's go to the relationship issues and the cell phones briefly.
Uh-oh.
No one knew that there was a relationship between Wade and Willis, according to Wade and Willis.
Because that sounds like
Not
an
a
affair.
soul was ever told that they were dating or that there was an intimate relationship.
Yeah.
Ever. They concealed it from all parties, from Daddy. Daddy didn't even know they had a relationship.
With an affair.
Suggest that somehow
It's a
in the beginning of 2021, January to whatever it was into April, that they couldn't have met in Hapeville. They didn't meet anywhere that would allow the public to see them. That's the reason why they were meeting at Yertes, because no one else was ever there. Remember the testimony? Who else was there besides Mr. Wade and Miss Willis? Both of them agreed. No one ever went there except them. They didn't go to where Daddy was in Miss Willis's house because Daddy was there and Daddy would know. No other prosecutors knew. No one knows except who? The one person that knew was Bradley and Yerty. Yerty was the best friend at that time of Miss Willis, and Bradley was the partner of Wade. Now, the only way that the only way that Bradley can walk away from very little time. So I'll skip that. Let's go to something. Motive. That's an issue. Whose motive in this case is the strongest? Fani Willis, Nathan Wade. Because if they testify truthfully on every point, what happens if the relationship started before November 1st? They get disqualified.
Yep.
Who has the best motive of anyone to lie? They do. Who has the most at stake to lie? They do.
Yep.
Who wants to stay on this case for whatever the financial reason may be? They do.
And more. Thank you, Mr. Sato.
Yeah.
There it is. All right. Thank you, everybody. I think it's been very much made clear by the argument and the made today is that there are several legal issues to sort through, several factual determinations that I have to make. And those aren't ones I can make at this moment. And so I will be taking the time to make sure that I give this case full consideration it's due. I hope to have an answer for everyone within the next 2 weeks. Until that point, if there are any other issues that come up, council can reach out and we'll have an order posted on the docket. Thank you all. We're off the record.
All right, Pete. Okay, let's stop this here. All right, so that's it. Yeah, that's it.
Thank you, Mr.
All right, cool. So now, what I wanted to do later before this here, let me get back on the thing. There we go. Before this whole thing started, I just popped in here because this was actually live happening now. But what I want to do is I'm just gonna, for a few minutes here, since I'm up and aroused and stuff, and I hadn't responded to Fani's interview that she did, not interview, but questioning. Yeah, we'll do that, and that way we could actually draw dots too and connect the dots on this whole case here stuff. Like this whole thing is super important, especially now. I'm telling y'all, because this election is coming up. All these things, all this stuff done in the dark is being revealed because it's time for the change. You know what I mean? Like in history, we've gone through cycles of different presidencies where it be the Republicans in charge. Then we go through cycles when it's the Democrats' turn. And whenever it's time for it to switch over power, you'll see that all kind of information will be coming out, and the exposure and stuff starts to happen to make more people outraged at it. So it kind of helps to encourage people to vote a certain way, you know. So so anyway, I'm just happy that this here is happening too, because it just, you know, gives credit to what I was saying earlier when I was saying how we need to get political, and this is going to help us to get the justice and stuff like that we were seeking from you know, for people, for victims and stuff like that. So let's go ahead and set up our next video. Let me move it over here. Yay. And uh-oh. Let me see here. I'm messing up here. All right, here we go. Oh, all right. So, all right, we're going to go over this here, and I'll point out the body language and the lies and stuff like that too, which we can go back and show how liars, they do the same thing, right? They do the same thing, but if you stick to the truth and the facts, the math and science, that's how you able to, you know, get it right all the times. But a lot of times these liars are real good at distracting, at distracting you to where you get confused and forget about what the actual, what really was going on and stuff too. Okay, so we're gonna go over here. For anybody who don't know, this Fani Willis is the DA in Fulton County, Georgia, and she has a history of doing some, you know, pretty vicious stuff, you know, and mishandling, misappropriating funds and different things like that, and firing people who try to speak out against the truth and stuff. So this personality spirit is in, you know, a lot of people. So a lot of times we can check different personalities and stuff like that by people's behavior. And the good thing about this whole social media thing is that people's behaviors are playing out right in front of us so we could look at them and analyze them and be able to, pick out how to tell when somebody's trying to pull the wool over your eyes. So here we go. This here is her testimony. It's real good. Now she is the district attorney, like I said, and what the facts are is that she hired a guy she was having an affair with, a married man, to prosecute President Trump on some stuff, right? So anyway, it was they're trying to disqualify her from the case because of this inappropriate relationship that she didn't disclose with the taxpayers, and that she was benefiting from paying him a lot of money and stuff like that. So, and also I tie in there too, like I was telling y'all before, when I don't remember, I think it was probably about a year ago, there was, I think 5 Black police officers beat to death this one Black guy. I can't remember the name. But anyway, how they are trying to hurt us by making us emotional by using things like racism and things like that. So Black people, most of us get emotional when we hear that somebody's racist and stuff, right? That's the quickest way to just shake us off of any type of foundation that we could be trying to build to, take back our freedom and stuff and stop being led and manipulated, right? So a lot of times, we have to make sure that we're not just responding emotionally, that we are critically thinking, right? So we can make some real changes and stuff. Okay, so without further ado, we're gonna play this, and I'm gonna show y'all the obvious parts when she's lying and stuff like that.
District Attorney Fani, Fani, last name is Willis. Ms. Willis.
So you can see here how nervous she is. Like she's, look at her respirations, breathing really fast and stuff. She's worried.
How did you know to come into the courtroom right then? There were people I was pacing in my office. Okay. And I heard someone yell, "His testimony is done." It only made sense to me that I would be your next witness. And I've been very anxious to have this conversation with you today. So
see, she's using her lawyer tactics here to, try to ascertain control over the thing, right?
Ran to the courtroom.
So as soon as you heard that Mr. Wade was done testifying, that's when you just assumed you would be the next witness?
It only makes sense.
See, like now she's being being sarcastic. She's actually, trying to bully the attorney that's questioning her, right? She's being defiant. It only makes sense.
Did you listen to any of the testimony?
I've been in my office pacing, ma'am.
I've been in my office pacing, ma'am. Look at her. She has an attitude. She's outraged. How dare you look at me? Look at me. We're supposed to be prosecuting the president over here. Don't be looking at what I'm doing.
Did you listen to any of the arguments?
I did hear the arguments this morning. It's ridiculous to me that you lied on Monday, and yet here we still are. And I did listen to that argument.
See, now she's trying to act like she's outraged and accusing her of lying. And a lot of narcissists do this where they will project what they're doing onto you. So she's lying.
All right, so that was it, just the argument, no testimony.
Right, I
How fast
listened
she's
to the argument this morning where Adam Abadi, I thought, did an excellent job pointing out how dishonest you were with the court on Monday. And I'm actually surprised that the hearing continued, but since it did, here I am.
Great. So
see, it's facial twitching. She's got twitching in the face. She is pissed. She's pissed that she is now in this seat.
let's just talk about what you did in preparation for today. Did you meet with Mr. Wade at all? Once the motion was filed, did you meet with Mr. Wade? And
did y'all see her squint? Pull it back just a little bit. Look at her face. Watch her squint.
words about some of the things that you said that were dishonest within this motion. So I don't know that it was a conversation.
Oh.
As you know, Ms.
Went the wrong way.
Did hear the arguments this morning. It's ridiculous to me that you lied on Monday and yet here we still are. And I did listen to that argument.
All right, so that was it, just the argument, no testimony.
Right, I listened to the argument this morning where Adam Abadi, I thought, did an excellent job pointing out how dishonest you were with the court on Monday.
See how she's trying to put it back on her?
I'm actually
It's a
surprised that the case
narcissist
continued,
move right
but
there.
since it did, here I am.
You lie.
Great. So let's talk about, first, let's just talk about what you did in preparation for today. Did you meet with Mr. Wade at all? Once the motion
Look at it.
was
Yes,
filed,
with the
did
minds.
you meet with Mr. Wade and talk
She's pissed. How dare you ask me about this? She's mad.
to him about the motion that I filed to disqualify you?
On January, this first January motion?
Yes.
I don't know if you could say talked about. I probably had some choice words about.
Now she's not answering the question. She's just making it be known how outraged she was at this whole motion and stuff. But she's not telling her what she did to prepare for the case, which is the question that she asked. What did you do to prepare for this case?
Some of the things that you said that were dishonest within this motion.
See how she keep trying to throw it on there? You said all this stuff. You was being dishonest, right? Look at her. She's scared and angry.
So I don't know that it was a conversation. As you know, Mr. Wade is a Southern gentleman. Me, not so much.
Okay, but my question was, did you have a conversation with
I
him?
didn't have a substantive conversation.
You did not.
I read this motion, skimmed it more so, and
How dismissive she's being with it. I've read this, you know, I mean, she's dismissing it because she's the DA. How dare you? And this is her courtroom, like this is her area, right? So these people are on her turf and they got her behind in this hot seat here. And she don't like that.
probably said some choice things to him about some of the lies they were told. And then printed in the media because, you know, we used to be in a day and time where you had 60 Minutes and people did stories and they verified information and you had this great reporting. But it seems today that a lawyer writes a lie and then it's printed for all of the world to see.
It says, Fani Willis, Fulton County District Attorney, facing allegations she financially benefited from her romantic relationship with Nathan Wade. Willis admits she had a personal relationship with Wade, but denies wrongdoing. Wow.
Well, I just want to make sure that you answered the question I asked, though. So my question was,
Overruled, Mr. Abadi.
I told you what happened. I read the motion. I am sure I told him what my opinion of it is. And past that, we had no substantive conversation.
you did not.
Is there something you didn't understand?
No, I just want to make sure that
Okay.
you did not have a meeting with him in the conference room to discuss the
All
motion.
right, next question,
No.
Ms. Marshall.
So in the conference room of my office within this week, you produced some financial document. That financial document was given to me.
Look at her.
And I'm not even sure who's giving it to him by name.
Yeah, go ahead and lie. Now she's digging her own hole because she's trying to explain everything. Remember how I was telling y'all about how you could tell when somebody a lie? Like a lie needs an explanation. A lie needs for you to set the stage, to set the scene, so you can hear how you want people to, what perception you want them to get.
Or Mr. Abadi gave it to me. And I think he showed me a document in our conference room. But as far as a substantive conversation, I don't believe I've had any.
I don't believe I have. See, that's how you can disguise the lie. Like, listen to the words that she's using. She's like word salad all up in here, right? So this way, it's not like it was a lie. I said, I don't believe I had, you know what I mean? But I didn't say that we didn't have a conversation. I don't believe. Right? See how she
Conversation with him
lawyer
that is substantive related to this.
Okay.
I have had conversations with him since you filed the motion, but they wouldn't be substantive to this. He sent me very nice sermons that have been done. And so we've had conversations about, did you listen to that sermon? things.
Too much information. That's how you can tell these are lies. Too much information, too much details. This is just a hearing, right? But she's trying to set out the whole case here.
Of that nature. And I would say they were in relationship to this because I think he did it to be kind.
Okay. Let's start back in 2019.
Mm-hmm.
So you and Mr. Wade met in October 2019 at a conference?
That is correct. And I think in one of your motions, you tried to implicate I slept with him at that conference, which I find to be extremely.
I see how this is the distraction right here. See, now you take offense, right? These are super moves that most narcissists do. And a lot of these attorneys be narcissists low key and stuff, especially these vicious ones that use their power to, control and to hurt people with and stuff, right? Because it's some videos of her listening to a whistleblower and then actually terminating that whistleblower shortly after them blowing the whistle.
Offensive. I stayed at that conference. Mr. Wade was my teacher. I did not meet him when he taught the class. I was standing outside talking to Lisa Reed, who was a judge. Me and her were just having a conversation. Mr. Wade walks up. I think they hug each other. They have some brief conversation. She introduces us.
Your Honor, I'm going to object.
Thank you.
When you ask a question, you can answer the question.
Look how fast you're breathing up.
I agree. I'm able to explain my answers.
I believe she's able to explain her answers.
And
That's Ms. Merchant. That's okay. I can handle it. Ms. Willis, I'll ask you to just listen to the answer, or excuse me, the question, and keep the answers confined to the question as best you can. I think you'll have more than enough ample opportunity on when the state is able to
It's highly offensive when someone lies on you, and it's highly offensive when they try to implicate that you.
See how she keep trying to go back in there and gain control over this thing here by bringing up the fact and accusing Merchant of lying.
Slept with somebody the first day you met with them, and I take exception to it.
All right. Well, Ms. Willis, she'll have the opportunity to explain all of that when it's the state's turn to ask more open-ended questions.
Yeah.
Ms. Merchant.
Thank you, Judge. So again, my question was, you all met at that conference, though, right?
We did the meeting. He, as I stated, he taught the class. I did not actually meet him when he taught the class. I walked out of the class, and I'm not sure if it was that exact class or we had went to lunch, but we were standing in the vestibule outside of the class. Me and Judge Reeves were having a conversation.
She throwing all these other names and stuff out there too, because she feels like she should be above any of this here reproach, above it.
I worked at a law firm I worked at back in 1996.
We're getting way afar. I mean, I don't mind her explaining her answers, but I literally just asked if they met at that conference.
Explaining how she met Mr. Wade, which was exactly the question asked by Ms. Merchant. These answers are more than appropriate.
Ms. Merchant, if you want more concise answers, perhaps you could lead the witness.
I will. Thank you, Judge. Isn't it true that you met Mr. Wade October 2019 at a judge's
He
conference?
hasn't gotten to the point where Ms. Willis should be treated hostile.
I think we
I
have.
very much want to be here, so I'm not a hostile witness. I very much want to be
Not
here.
so much that you're hostile, Ms. Willis, it'd be an adverse witness. Your interests are opposed to Ms. Merchant's.
Thank you. Merchant's interests are contrary to democracy, Your Honor, not to mine.
All right, let's
Judge, I
proceed.
would
We can keep things moving. Ms. Merchant, next question,
Yeah.
please.
Okay, so we've confirmed when you met. After that, isn't it true?
No, I need to explain this, and I think I get to explain my answers. When I met him, Judge Reeves introduced us. He handed me his business card. I'm unsure if I handed him my business card, but we exchanged information. He said, if you ever need any help, give me a call. And he walked to the parking lot.
Too many
So
details.
after that, you started dating shortly thereafter, correct?
A lie. That's one of your lies.
Wow.
Do you know Robin Yurdy?
I know her as Robin Bryant. I knew her. So Robin did not go to my college. She went to the college.
Look at all this extra information.
Howard University. She went to Morgan State.
See, like, look, listen, this is how you could tell she's lying. She's telling a story here. All this. She's asking her simple questions that's like mostly yes or no, you know.
I met her through some people I knew. In college, we hung out a bit, not much because she was in Baltimore and I was in Washington, D.C. But we hung out a bit. After college, I lost contact with her. I probably didn't see Robin again until maybe 7 or 8 years ago, a chance meeting here in Atlanta. but we did not have a consistent relationship from when I left college and came to Emory Law School here in Atlanta. But 8 to 10 years ago, just by happenstance, I ran into her. So she was in Atlanta.
You have been friends with Robin for 30-something years.
Did you hear my answer, madam?
Wow.
Yes. And I'm asking if you've been friends with her for 30-something years.
I've known her for 30-something years. We certainly hung out and partied together in college. She was from the DC area. She would come home, we'd party together. Wasn't close, but she was certainly in the girlfriends that partied together. And then, like I said, I ran into her about 10 years ago in Atlanta, Georgia.
So
but we didn't talk throughout that time period. I didn't see her. I didn't even know where she was. When I ran into her, I was surprised she was in Atlanta. And so, yes, I have known her probably since 1990, 1991, but we have not maintained a consistent relationship that whole time.
For the last 10 years or 5, whatever you'd like to classify it as, have you been friends with her?
I have not spoken to Robin in over a year. I certainly do not.
See, notice how she still didn't answer the question. She just keeps talking with more story. I've known her for this, that, and the other, but she didn't say yes or no. These are yes or no questions that she's being asked. But she's with all this story, and this is how liars do to try to keep control over the situation. So,
not consider her a friend now. I think that she, there's a saying, no good deed goes unpunished. And I think that she betrayed our friendship.
So let's narrow it down, the timeline now. So my questions are going to be from the time period of 2019 until she no longer was employed for you, the last time you all talked. So all of my next questions are just focused on that time frame, okay?
Yes, ma'am.
Up until she left your office.
Yes, ma'am.
During 2019, you all were friends, correct?
Yes, we knew each other in 2019.
During 2020, you all were friends, correct?
We were friends during that time period.
During 2021, you all were friends, correct?
Yes.
Okay. And such good friends that when you needed a place to stay, you asked her if you could take over her lease.
That's a lie.
You did not move into her apartment?
I did, but that's not the way you characterize it is wrong.
I asked if you could take over her lease.
I did not ask if I could take over her lease.
Did you move into her apartment?
I moved into her condo in April.
So the attorney merchant, she's not really good with the questions. You can tell that, she also is an experienced attorney, so she knows how to answer and the different words to put in there. So it may not be perceived as telling a lie.
Well, of 21, the circumstances around that were that Robin met her husband. They wanted to move into another and separate place. She wanted to get rid of her condo. My father was living with me at the house. Because of this case and because of my stance on gangs, my life was being threatened regularly. My father urged me to leave our home. At the same time, as luck would have it, Robin wanted to give up her lease because she wanted to move in with this new man she met, who eventually became her husband. And so as life circumstances worked, my dad was begging me to leave the house. He was afraid for me, afraid for his grandchildren. She wanted someone to take over her lease so that she didn't, have to pay a fee or get abandoned. And so I don't remember when, but probably March or April of 21, I moved in and take over her lease.
And did you pay her or did you pay the leasing agent?
No, I don't even know who the leasing agent was. I paid her.
You paid her. Did you pay her cash or did you use card?
Cash, but mostly I paid her via Cash App. That would be the most convenient thing. So I would not only give her rent, but then like when the utilities would come in, whatever the utility was, she might be like, I need $70. I need that.
Okay, now she is talking now freely because she not realizing that the questions, when these attorneys asking you questions, they pretty much already know what the answer is, right? So she's kind of allowing her to dig a little hole here. She's establishing the fact of her making these cash payments, but through an app, a way to be traced. Like every payments that she made to this lady were traceable with Cash Apps, with the Cash App application, right? There was a way to trace the money because Cash App is going to show that the money came from the bank to this app, and you were able to pay somebody with. So this is a way that they're showing that you have always traced the money that you've been using, right? And she's not even realizing that when she later on say that she's paying Mr. Wade with all these boatloads of cash that she just kept at around the house, you know, it doesn't make sense that why are you paying the other lady, yeah, with traceable
$100, whatever it was. And we never had a problem with money. Whatever she told me it was, I never asked to see a bill. I never questioned her. I just gave it to her.
What percentage would you say you paid cash versus cash out?
Oh, the vast majority was cash out. I don't know what percentage, I'm not gonna guess that, but the vast majority was cash out. But there would be times she would say, you know, this bill came in at $70, here goes $70.
Did you have a monthly rent amount that you paid her?
I can't remember. It was $1,500. I can't remember what it was. And it would vary, which I don't understand to this day. But like I said, I never questioned her.
When did you move out?
She said it was, that's what I paid.
Yeah.
When did
I
you move out?
abruptly moved out in February, late January, early February of 22.
Of 22.
Yes,
February 2022, is that what you said?
January, February of 22. I
best.
believe it is January, but I paid her half the rent of February of 22 is what I remember. And because I was offering to pay the whole rent, even though I didn't live there, I didn't think it was right. And I ended up just paying her half the rent.
So that's after you moved out. You said you paid her half of that. Okay. And the time that you said you had to move out of your house because you were scared, did your dad stay there at your house?
My father was concerned. Yes, we were both concerned.
Okay. But he remained there.
My father was 80 years old. He would have been 79. He was scared to death of COVID. You have to go back to when this was. My father's an older man. I wanted him to move out. We had some discussions about him moving out. And what he decided was the risk of COVID was more dangerous than the risk of the people that were threatening.
2021, we were
more worried about his daughter and his grandchildren than his own safety. You'll get to meet him and you'll understand he doesn't scare too easily.
She's already knowing that her dad's testimony is all staged. So you'll get to meet him. So she's setting the scene to let you know why she's explaining everything. So it makes sense to why she had the cash, because y'all about to meet him, because my dad about to let y'all know why, you know, I get to do the cash thing. You know, I'm daddy's girl, and this is how this going down.
So his grandkids were living at the house as well at that time?
Well, I don't know how old your children are, but when you have adult children, they leave and they come back. They leave and they come back. So there have been periods of time that they're there, they come, they do whatever they want to do. Children do what children do. As long as their mother has a house, they'll come to it. Unfortunately, now the threats because of this case have gotten so extreme. I just pay a mortgage and no one lives there.
And that's what I was going to ask you. So when you moved out in, I think you said April 2021, you left your dad and your two kids at the house?
My dad and my two kids were not at the house.
They were not. Okay, so they didn't still live at your house?
My youngest daughter certainly did not live there. Okay. My oldest daughter would.
She said her dad was too scared of COVID to leave the house. So she's like, here's a lie. She just said now the dad and the children weren't at the house. But just 2 breaths ago, father 79 and was extremely worried about COVID. So he didn't want to leave. Now, she just said that her dad and her children weren't at her house. They were not there.
Come back and forth. I can't say month for month when she was there or when she was not there. I know that she has been there post me moving out. At this time, no one is at my house.
Okay. So at some point after you moved out for the safety reasons, at least one of your children did come back.
Ms. Merchant, can we get to either the relationship or the financial benefit?
Yes. Let's see, we were back at 2021. So you were still friends with Miss Yurdy then. Were you also friends with Mr. Bradley?
I've never been friends with Mr. Bradley.
You've never been friends with Mr. Bradley?
No, I don't consider us to be friends. I don't dislike Mr. Bradley, but
I don't see more story there, right?
Consider us to be friends.
Is he someone that you would have in your phone and you would message with?
I might have text messaged him.
Okay. Would you text message him and Mr. Wade on the same conversations?
I don't recall doing that, but if it happened, it wouldn't surprise me.
Okay, so that wouldn't surprise you, the three of you. Okay. How frequently would you think that the three of you would have texted
Not
in a group
very,
chat?
I wouldn't think very often, but you're asking me to recall. I don't even know what time period you're asking me to recall, but I'm not going to speak to that because I just really don't know the answer to that. So I don't want to speculate as to how often that would happen. But it's not out of my practice to text two people on one text message. So if you told me that happened and showed it to me, it wouldn't surprise me, although I have no recollection of it.
But there would be some record
no
of it,
recollection.
or the phone records would have some record of those texts.
Perhaps.
That's how you can do the lie and get away with it when you just say, I have no recollection of it, right? So you can't prove that I don't remember this or not. And I didn't say that it didn't happen. So it's not technically a lie. Real smart.
Talk about, you said that sometimes you paid Miss Yurdy cash. When you went on vacation with Mr. Wade, let's just go one by one. Let's start with the first one. What's the first time you went on vacation with Mr. Wade?
I think the first time we went on vacation was around April of 22. And it's a vacation is a stretch, but I'm trying to be comprehensive. I recall April of 22. His birthday is March the 18th. So that would have been his 49th birthday. I took him to like Tennessee for the day. I think we went to a museum. I think we might have stayed the night. I'm not sure. But I mean, Tennessee's kind of hard to call a vacation, but I just am trying to be inclusive. And like I said, I know it wasn't more than a day.
See how she's giving more details and stuff, just details, but still not really answering the question. But she's painting a picture. So this is her way of being able to verify her statement so they can be more believable.
She didn't spend the night.
I think that we did. That's what I'm telling you. I think that there's a possibility that we stayed that night in it.
I think, again, so there's a possibility.
April of 22.
Who paid for the hotel?
I think I did. It was his birthday.
And would you have used a credit card?
Probably maybe a debit.
Uh-oh.
When I started dating Mr. Wade, it was right around then.
April 2022?
22, yes.
2022.
It was 20. It's not like when you're in grade school and you send a little letter and it says, will you be my girlfriend, and you check it. I don't know the day that we started seeing each other, but it was early 22 is my recollection.
Okay, early 22. And you all went to Florida on vacation as well?
I don't recall going to Florida on vacation with him.
You never went to Florida with Mr. Wade?
When we went to get on the cruise ship, we went to Miami.
Okay, that's the only time that you went to Florida with him?
I think we went to Miami and spent the night. That's my recollection.
Okay.
I think we spent the night. That's my recollection.
Okay.
I think we spent one night so that we wouldn't miss the ship. That's my recollection of our
Paid for that hotel.
She thinks.
In Miami? I don't remember that.
And how'd you get to Miami?
We would have flown. And we've done that, so that I'm clear. We've done that twice. I think one time we stayed, and I honestly can't tell you, did we stay when the ship left or did we stay when the ship came back? I also can't tell you.
Out there.
So,
let me be clear. I don't know if it was this or if it was that, right? This is how you could tell these are lies, because the truth doesn't need explaining. The truth doesn't need an explanation. It just is.
There's 2 cruises out of Miami. There's one that's in that October time period that was with his mom. And then there was another that was a New Year's Eve trip. I know I paid for the New Year's Eve trip because the tickets were $697 each. And I thought, this is ridiculous that the tickets are $700 to go to Miami. But when you travel during New Year's Eve, they get you.
So let's just back up and talk about the first time that you went to Florida with Mr. Wade. That was the time that you said you stayed in Miami at the hotel the first night?
That's the time I told you I am not sure. So I'm not sure of 2 things. So I want to make sure that my testimony is clear. I'm not sure if we stayed in Miami on the October trip I'm not sure if we stayed in Miami on the December trip. I just can't remember that. And I also don't remember, so that the record is clear. I don't remember if the necessity was as we got on the ship or we got off the ship. But I do remember there was a night spent in Miami.
That's how you could tell these are lies, because if you don't remember something, how do you know that you don't remember it? But I do remember this, but I don't remember that. She hasn't even been asked any questions. Either this is her story.
Because either whatever, I don't remember.
Yeah.
But I think that there was
Whatever,
a night spent in
I
Miami.
remember.
That cruise is the one that you took in October, right?
Ma'am, if you have something to refresh my recollection, I'm intentionally trying to not be difficult with you, but I don't want to make up something.
Right.
I know that on one of those 2 trips, we stayed in Miami. I am not sure right now. You're asking me about.
Oh, I'm sorry, you misunderstood. I was not asking you which night you stayed in Miami. I'm asking if you took a cruise in October 2022 with Mr. Wade.
Yes, and his mom.
And
see how she keep being distraction by answering something else with a whole big story? This is what liars do to distract you. So now we're talking about this, right? Instead of the facts.
his mother, that's what I was asking.
Yes.
Is that the first time you met his mother?
Yes.
It was on that cruise, and that was Royal Caribbean, I believe?
I honestly don't remember what ship. I know we've taken 2 cruises. I don't know what the ships were.
But he paid for the flight and the cruise on Royal Caribbean that time.
So yes, he paid. He is the original one that does it. He has something called Mr. Wade is a world.
Now remember, she had just said that she had bought the tickets and she paid. Now he's paid.
Traveler. I'm not as versed as him. He's been to 6 of the 7 continents.
Because remember, she was outraged that the tickets, was almost $700 each. So she supposedly paid, right? Now the tables are turning and now he's paid. This is how you could tell also when someone's lying, because the truth doesn't change. Liars are constantly repurposing the story to make it sound more truthful. So now she has to change the story. So when she introduces that she's paid him back with the cash, now it's more believable. But liars lose track of the different stories they tell, because most of the time they are telling them as they get confronted with it, with the truth. So then they'll come back with a new lie to counter.
And so he has both a personal travel agent and he also has a cruise travel agent. I don't know anything about either of those kind of travel agents. So he is the one that would book the travel. But we need to be clear when we're talking about just because he booked it doesn't mean, I don't consider him having taken me any place. Let me just be honest. The only one that's ever taken somebody someplace is for his 50th birthday. I consider that I took him to Belize. And I took him to Belize because, I don't want to discuss his personal business, but I'm happy Mr. Wade is still here with us. And I did 50 days.
His personal business, but let me just put it out here that, he had this terminal, he has some problems there, right? Look at her face. This lying heifer.
Very big.
So still on that October Royal Caribbean cruise, even though he had a travel agent. I'm sorry.
If you do me a favor, I don't know what cruise ship, what time. So if you'll help me and say October cruise with Mama or the New Year's Eve trip with his sisters, I'll be able to, we can communicate. I just don't know what ship.
Wait, so now sisters were involved in it too. See how more and more people is getting added to the story. So it sounds more like it was just like, some friends hanging out and stuff like that. It's nothing romantic, right? And somebody brought up a good point here, said she's the balance, says she's a DA but has a poor memory. Exactly, right? Lies.
with Mama. That's what I'm talking about.
Yeah.
He paid for the cruise and the flights for that trip.
So he called his cruise agent.
See how we going to back off into this story. She just asked, did he pay for the trip? But liars have to give you the story. Otherwise, they have to convince you that this is the truth. That's why liars have to tell the story, because the truth don't need, like I said before, multiple times, the truth does not need explaining. The truth just is.
And he booked that through them because he has a cruise
Look at her
agent.
face.
He also has a regular agent. I don't know the cruise agent's name.
So I wasn't asking about his travel agent. I was just asking,
But
if
I'm
he
trying
paid
to.
for those.
He did not, though.
Okay.
Because the reason I consider that he did not is I gave him his money back.
And I was about
So-
to ask that, but initially he paid for that.
Yeah, he called his cruise agent. Like, I think they have his card on record. They
See this face? Like this, how you can tell when somebody else is lying too, because they try to do this face like, yeah, like, this is how the thing goes. Like, yeah, to cover up the fact that you just lied. Because he did pay for the trip. But this is the reason why I don't think he paid for it, because now she got to give this baloney story.
do whatever.
Okay. So initially he paid for the cruise and the flight to Miami and the Royal Caribbean cruise.
And my understanding of that October cruise is like it was a pack.
And see how she's trying to keep verifying her statements by saying my understanding or I think and things like that, that's vague. So it's not like I actually lied. I said I believe.
Package the lady did for him.
So, and I'll get to the reimbursements and all that. I'm just trying to confirm he paid for the flight and the cruise in October.
And I think that when you say things that way,
yes or no?
I want this record to be
Initially.
abundantly clear that he calls his travel agent, he calls his cruise agent. They do whatever he tells them. He's like on a first name basis with these people. They do it.
More
And
details.
then he tells me how much it is, and I give him the money back. I don't, just like you're asking me about the money with Robin, I don't do my friends like that. So if you tell me it's a G, then you're going to get $1,000. Whatever it is, I didn't ever make him produce receipts to me. Whatever he told me it was, I gave him his money back.
Isn't it true that he paid for the
He did, gave him the money back. And next, she playing the game here. She playing the game. She wants her, now you got to prove that I'm lying.
cruise and the flight on his credit card? I'm not asking about reimbursement or after. He used his credit card to buy the cruise and buy the flight, correct?
I have no idea how he paid for it,
Okay.
if it's a credit card, if it's a debit card, but certainly he called his cruise agent. Like how many people have a cruise agent? He calls his cruise agent, tells them where they want to go. They tell him what's booked. You have to remember, he paid for that initial was me, him, and his mother.
And then after that cruise, you all flew to Aruba and spent a couple days in a hotel there, correct?
Right, and his mother was not happy.
He
that we left
initially
her
Look
paid
at
behind.
that. You got to put that in. His mother was not happy. Look at that. More distraction. More distraction.
He initially paid for that.
For Aruba, yes, ma'am.
So let's talk about both of those. I know he initially paid for it. Did you pay him back?
For the cruise and for Aruba, yeah, I gave him his money before we ever went on that trip.
You gave him cash before you ever went on the trip?
Mm-hmm.
Okay. And so when you got cash to pay him back on these trips, would you go to the ATM?
No, lady,
You would not go to the ATM.
no.
Okay. So
Yeah.
Fulton County pays you direct deposit, I assume?
Yes, Fulton County and the state of Georgia both pay me direct deposits.
Okay. So the cash that you would pay him, you wouldn't get it out of the bank.
I have money in my house.
You have money in your house. So it was just money that was there.
When you meet my father,
I see there. She's setting the stage. My daddy going to explain all of this. When you meet my father, you're going to see.
he's going to tell you as a woman, you should always have, which I don't have, so let's don't tell him that. You should have at least 6 months in cash at your house at all times. Now, I don't know why this old black man feels like that.
See how she throw that in there too? This old black man. So people could feel like This is what black people always do. Black people always have a secret stash of cash because of slavery. It's because of slavery that we don't trust the banks. You know, she wants us to believe that she's the whole district attorney and that she keeps a safe stash with cash.
But he does. When we were growing up, my daddy had 3 safes in the house. So my father's bought me a lockbox, and I always keep cash in the house. Now, I don't do it to the degree that my father would do it, so he would probably be ashamed with me, but I always have cash at the house. That has been, I don't know, all my life. If you're a woman and you go on a date with a man, you better have $200 in your pocket. So if that man acts up, you can go where you want to go. So I keep cash in my house, and I don't keep cash as good in my purse like I used to. I don't go on many dates, but when you go on a date,
see there, more story. So the liars always give you the reason why. See, the truth don't need explaining.
Have cash in your pocket.
So my question was, where did that cash originally come from? If it didn't come out of the bank?
Cash is fungible. We've had cash for years in my house. So for me to tell you the source of when it comes from, when you go to Publix and you buy something, you get $50, you throw it in there. When it's been my whole life. When I took out a large amount of money on my first campaign, I kept some of the cash of that. Like, to tell you, I just have cash in my house. I don't have as much today as I would normally have, but I'm building back up now. So you just put money in. It's a very good practice.
There, see, everybody does that. You know, I kept some of the money from the last campaign when later on she's going to say she was broke, that she lost all the money from what she put up in that campaign. More lies. So she's already dug herself into a hole here by talking, thinking. Most of these narcissists think that they are smarter than everybody, that they can lie their way and convince people to believe them. That's why they always get up there and start talking, because they believe that they are smarter than you and that they are good liars, that this is the story and you're going to believe whatever I tell you.
Advise it to all women.
So you can't identify when you came into this cash or where the cash came from?
I didn't say I couldn't identify it. No, nobody gives me anything. I am sure that the source of the money is always the work, sweat, and tears of me. What you asked me for is, when did the money go in there? What I am trying to tell you is, so I got divorced in 2005 from my husband. No, it's important. You said, where did the money come from? And I need to tell you where the money came from. And so for many, many years, I have kept money in my house. That money in my worst days has probably only been $500 or $1,000. At my best days, I probably had $15,000 in my house at cash. At all times, there's going to be cash in my house or wherever I'm laying my head.
The money that you paid Mr. Wade, the cash in October of 2022, you do not know where that money came from.
I do know where it came from. It came from my sweat and tears.
You know which job it came from. Did it come from Fulton County or did it come from a private job?
It came from, what are you talking about? So it could have come from a private job, because before I was DA.
It could have come from, so she now is doing a Tarzan, going from rope to rope, swinging here from these lies, because she realizes that she doesn't have a valid way to prove where this money came from. Like, there's no trace of it, no way to say. So she's trying to paint it vague, so you can't really have me pin it down to when and where the money actually came from. Over so many years, my whole life, I've always kept cash, just here and there, cash.
I was in private practice, so I earned money during that time period. It's probably in there.
You don't know
could have. What do you mean? I don't know where it came from.
I understand the situation. We can move on.
Okay, thanks. Same with Aruba. You don't know where that cash came from either, right?
Ma'am, you are mischaracterizing my testimony greatly. I'm not going to allow you to mischaracterize my testimony. I know that I keep money in my house. The amounts of money I gave Mr. Wade it was never that serious. I don't think I've ever handed him more than $2,500 in a reimbursement. So we're not talking about $20,000 in cash. I don't have $20,000 in cash right now. The most I ever gave him, I know I gave him $2,500 when we went to Belize because we went to one
more
hotel.
story. When they tell the lie, they always qualify with, because I know it was at 7 o'clock because the sun was setting on the headboard of the thing, and that's why it was morning time. Yeah, I mean, but baloney. Too many details.
And then we went to a second hotel. That $2,500 I actually gave him while we were still in Belize. I know that the Aruba trip, the one that you described with his mom, I think I gave him about $2,000 for that trip for like total.
His mom went to Aruba with you?
The Aruba trip. So I consider that to be one trip. So we got off of a cruise ship and then we went to Aruba, which is why I cannot remember, is that the time that we had to stay in Miami to wait for the flight for Aruba. So I consider that one trip that we didn't like come back to Atlanta and leave. We flew down to Miami. We got on a cruise ship. We spent a couple of days with his mama. We came back to Miami. When we came back to Miami, either that day or the next day, we flew to Aruba. We spent a few days in Aruba and we came back. That was really one trip. Even though we went two places, it was one trip.
So let's talk about the California trip. Is that when you were moving your daughter out to California? When you all went, or did you have two trips to California?
My daughter doesn't live in California.
Did she ever live in California?
I'm not discussing to you the location of my child.
Yes, she did.
How many times did you go with Mr. Wade to California?
Once.
And you all stayed in Napa Valley and he paid for the plane tickets and the hotel?
He paid for the plane tickets and the hotel.
And what did you pay for on that trip?
I gave him much less cash that time, probably $400 or $500. And then I paid for a bunch of stuff. I think we did 2 different wine tours that you do, which are pretty expensive. I think I bought him, he likes wine. I don't really like wine, to be honest with you. I like Grey Goose. I bought him a bottle of wine while we were there, and the sippings that you do. I can't remember how many, like 4 or 5 different places you go. I remember we went to.
I know, huh? That's what I'm saying. For these details,
this place that they do pairings. That was the most expensive thing that I think that we did while we were there. So they would pair.
It's all coming back.
They would pair champagne, chocolate, and caviar. It was a 3, and it was like 3 different things. Sweden, Russia, someplace else.
Red caviar, and then there was a lady who was walking the dog. I know that because the dog reminded me of when I was 12 years old. Another lady, she had a dog just like that, and she used to walk the dog all the time. So when I was there and was tasting the caviar with the wine, I don't like wine because I usually do just Grey Goose. But because I saw the lady with the dog there, and that's how I know that, yeah, that's what happened.
Most expensive thing we did that trip, and I paid for that.
You pay cash
for us doing that? Mm-hmm. Yeah, I think. That trip did not cost me a lot of money.
Listen,
I might have took.
See how she walked it back after she said you paid cash, and he was like, "Well, yeah. Oh, well, I might have, you know what I mean." But first, she just announced all this money, right? That she paid and gave him $2,500 before they even got there, and now she's paying for all of the fun and activities on the trip, and you're paid with cash also. Everybody always only have a finite amount of cash. So if you've already given away the $2,500, where did the next $2,500 come from? And then where did you get the $800 or the $700 that you were spending on the trip? Like, and you had cash with this too? Where is this pot of money?
Like $750 in cash on me because we weren't gone very long.
I'd only asked if you paid in cash. I don't need to know the amounts.
When I travel, I always take cash.
And is the cash that you keep in your house, or do you keep it at the condo that you were living in?
So at that point, it wouldn't be at my house. And I'm sorry if I was not clear. The money would be wherever I laid my head. So I wouldn't leave the money at the house. I was unclear.
So no. You brought the safe over there with you too? She wouldn't leave the money at the house, right? So now, yeah, okay.
money's gonna be where I stay.
How much did you pay for your trip to Panama?
To where?
Panama, I believe.
I didn't go to Panama.
I may have the location wrong.
I never went to Panama.
So
Mr.
after
Wade went to Panama with his frat brother.
Oh, he went to Panama with his frat brothers. So tell me about, let's see. So I want to make sure I've got them. I've got Belize. You already covered Belize. You covered the.
So let me tell you our real trips. In October, we went on the cruise with his mom. We got back from the cruise with his mom and we went to Aruba. I consider that one trip. Second trip, New Year's Eve, we went on a cruise to the Bahamas. That's the second trip. I want to make sure I get this right. Third trip, 100% on me. I think he might have spent $200 on that entire trip. We went to Belize. That was my trip. That was, his 50th. And then Napa Valley, we went around May. I don't know the dates, but it seems to me like it was close to Mother's Day.
And those are the only trips?
So that the record is complete. I can remember one time driving to, where were we? South Carolina, and we met my sister for lunch with her man.
I can remember, come on now. Lie.
When was that? I don't know, but we didn't stay the night there. But I guess people would consider that a trip if you drive somewhere and you come back. That was insane because it was like 5 hours to drive. We ate lunch and we drove right back. I can remember driving to some little town in Georgia. I don't even know where I was. I had never been there before or after. There's some boat you can get on over to, and they're like a slave thing. If that gives anyone any reference, we didn't do that.
The Black History.
I remember doing that. I remember driving one time to Charlotte. We had lunch with one of my very close girlfriends. And again, we drove to Charlotte, met my girlfriend for lunch, and drove right back. So that's a trip. We didn't stay the night there, but I just want to be complete in my testimony. We drove someplace, had lunch, drove back. I don't remember another driving someplace distant for lunch and coming back to Charlotte to see a girlfriend, to meet my sister in South Carolina. We went by ourselves when I told you about that remote place in Georgia.
And that's about it.
We could have driven someplace else and had lunch and came back, but that's all that comes to my recollection right now. There could have been another place we drove and had lunch. My security team was very clear to me. I'm not to be out and about in Atlanta without them. And so for me to do something just very normal that a normal person would get to do, if they weren't prosecuting this case, I got to drive 4 hours to do it.
And that's what I was going to ask you. Your security detail, did they take you to and from your house?
So I haven't been able to enjoy my home.
Condo, I'm sorry.
In March.
Where you lay your head? Did they take you to and from where you lay your head?
99% of the time.
Would they take Mr. Wade to and from wherever you laid your head?
That has never in the history of ever happened, ever, okay?
Your security team has never taken him?
From my house? That's a lie.
I'm asking if they've ever taken him anywhere.
And I'm telling you that that's never happened.
Now watch her put in there from her house, right? So this way, so she'll throw in a detail and dispute that. That's what liars do when they are confronted with the truth and they know that they've been caught. They'll throw a detail out there and argue about that. He's never been taken from my house. Like put that on there to where it avoids being honest about the true question, which is, have they ever taken him anywhere, right? So she put in a specific spot to argue no to that.
Happened.
So your security team has never taken Mr. Wade
My security team has never taken Mr. Wade from any place where I have lived and brought him here. Never, not once, not ever.
Have they ever taken the two of you together?
To where?
Anywhere.
Well, we've left this building and gone to lunch, but I go to lunch so rare.
That's a yes or no answer. But see how liars do? They wear you out. That way you can get lost in what answers that you're trying to, where your proof is at.
Rarely, that is a very rare occasion, I am sure. And let me be clear, it wouldn't just be Mr. Wade. So I'm sure my security team has taken me to lunch. probably been a time I've left here 7 o'clock, gone to get something to eat. And I don't even know that they would have taken him or he would have driven himself.
With me on that.
But they've taken me to do that. But we're talking very few, very far in between. Most days I don't even eat lunch. And when I do, it's because my assistant has heated up some bag, something, and I eat through meetings and eat in my office. It's not a practice of mine to go to lunch.
During the time period that you were dating, would your security team ever take you two together?
I went from, did the security team ever take y'all someplace to, I usually don't even take lunch. Where did the lunch come from?
No.
Never.
If there was a lunch that occurred that I just described.
If there was a lunch, right? So these are other ways to tell the lie without it being a lie because you said if.
If there was a meal that occurred that I just described, anything outside of that, and it needs to be very clear. Not often, once, twice, because I want to be over inclusive. I'm saying once or twice. I'm not certain that it happened, but I'd rather be over inclusive.
So your office objected to us getting Delta records for flights that you may have taken with Mr. Wade.
And well, no, look, I object to you getting records. You've been intrusive into people's personal lives. You're confused. You think I'm on trial. These people are on trial for trying to steal an election in 2020. I'm not on trial, no matter how hard you try to put me on trial.
So my question was,
she feeling confident on that one, but yes, you are, baby. You are on trial.
Do you have any problem?
I object to getting any personal records of mine.
We're not dealing with privilege through a witness.
And I'm not, no, I'm not dealing with privilege. What we had offered to put them in camera for the court to review. And I just want to know if she has any
That's not
problem.
something you deal with a witness.
Okay, you have to file as part of your job something called the income and financial disclosure report, correct?
That's correct.
And you filed your first one. So you filed 2 to date, is that right?
Is it 2 or 3? I probably would have filed 21, 22, and maybe I haven't filed 23 yet, because isn't it due like June of the next year?
April, I believe. So you filed, let's see, you filed your first one, it looks like April 15th, 2022, and your second one, April 17th, 2023. Does that sound familiar?
That I don't remember the dates, but you're an officer of the court. I'm gonna hope you're telling the truth now.
May I proceed?
See how she keep a little low key. I hope you tell the truth now. Trying to establish the fact that the attorney who's asking questions is a liar. She's good.
Thank you. I already gave the state a copy. Exhibit 20 and 21. If you can look at those. They're part of the certified records.
Can somebody bring me some? Yeah. Guys are getting a little old. Yes.
Okay.
Yes, ma'am.
Those are the ones that you filed.
This looks like me for sure. Yes, ma'am. Yes, ma'am.
Judge, we'd move to admit 20 and 21.
I think you need to delineate which one's which
20
one's which.
is 2021, so it accounts for the time period, Your Honor, January the 1st, 21 through December the 31st, 2021. That is Defendant's Exhibit 20. Defendant's Exhibit 2021, it accounts for the time period, January the 1st, 2022 through December the 1st of 2022.
All right. Any objection to exhibits 20 and 21?
Nope.
Another counsel admitted without objection.
When did your personal relationship with Mr. Wade end?
Our personal relationship ended in this year. So let's be very clear so that we don't mix words. I don't want to mix words in here. Mr. Wade is my friend right now. Mr. Wade, I would say, has been my friend since 2020. I think he started out as like a mentor and a professional colleague. He became my friend and somebody that I really respected. I feel very indebted to Mr. Wade for taking on the task of this job. And he is certainly my friend and one of the people that I respect the most. So if you ask about a personal relationship, I consider myself to have a personal relationship right now, Mr. Wade. I consider myself to have a personal relationship with Anna Cross. I consider myself to have a personal relationship with Mr. Abadi. I consider myself to have a personal relationship with Andrew Evans.
Okay, let me just
And so
clarify that
I
before we
have a
go.
personal relationship with him as we speak right now.
A romantic
I don't think that's what you're asking. I think that's what
romantic
you're asking.
relationship. When did your romantic relationship with Mr. Wade end?
My-
Did it end?
Me and Mr. Wade, we are good friends. My respect for him has grown over these 7 weeks of
Wow.
attacks.
And this is done so she can have time to think about what the answer should be, right? Since, you know, the lie, now she's thinking. So she's buying herself time with more of this here story here, right? Because like I said before, truth doesn't need explanation. The truth is just the truth. You know, somebody say when your birthday is, you don't have to say, well, you know, really, you know, I was born at like 7:30, but see so the date would have been, you know, you don't, it's just what it is.
We are very good friends. I think, but for these attacks, it would have been a friendship that as life goes, he would have.
See that? All this here story, February, January 22, whatever it was. Why don't you just say that?
Stopped having. I think that you have cemented that we'll be friends till the day we die.
Look at her face.
I just have an answer to the question.
I can handle Mr. Seda. Let's have it.
She asked about a personal relationship.
She asked when the romantic relationship ended. That's the question.
It sometime in I'd say late summer of 2023. So I don't believe me in this is what you're really asking about. This is the salaciousness of all of this, right?
No, I'm just
When
asking
you're-
about your romantic relationship. When you stopped dating.
I think that me and Mr. Wade, so he's a man, he probably would say June or July. I would say we had a tough conversation in August. So that men in relationships at the end of physical intimacy, women in relationships when that tough conversation takes place.
And where, when did he come to, I guess, the condo? I'm not sure.
Not only does she play the black card, but she plays the woman card too, man. She's just putting us back so many years.
What you called it, condo apartment. Would he come and stay at that condo or visit you there? I'm sorry, visit you there.
What condo, what apartment? I want to be clear.
So not your house. I know you classified one as house and one as condo. So I'm trying to use those terms.
So but there's been more see, what you don't understand is because of this case, I got to move. And so I
Ms.
need
Merchant, if you could ask a more precise question.
yes, please give me the time period. that we're
Mr.
talking
Wade
about.
visited you at the place you laid your head.
When?
Has he ever visited you at the place you laid your head?
So let's be clear, because you lied in this. Let me tell you which one you lied in. Right here.
Yeah. See how look at her. She didn't drove way over to here, right? When the question was, has he visited you at a place where you laid your head? Well, let's go. But now she's pointing out all these lies. Listen to this.
Right here.
No, I'm gonna-
No. This is the truth, Judge. And it is a lie. It is a lie.
Ms. Willis?
You see.
Mr. Seda, thank you. We're going to take 5 minutes. Be back in 5.
How often did Mr. Wade visit you at a place where you were living between 2019 and 2021?
So you want to start with the lie that he lived with me in South Fulton in 2019, a home he's never been to. That's one lie you told in your document.
See there? How she keeps drawing it back there to try to keep the control.
No,
Judge, I didn't ask her about that.
Ms. Merchant, I want you to ask a very precise question. I think she's saying and answering that he did not live with her. So why don't we break that up into smaller
Ever.
parts?
And I didn't ask about living.
But you put in your, while we're talking about professionalism, while we're talking about professionalism, she put in 3 different documents
Well,
he
she'll
lived
have
with
the
me.
full opportunity to respond.
In
And filed that with the court.
in 2019,
He's never been to South Fulton. In 2019, I lived in South Fulton. He has never been to my residence in 2019, ever, not once.
in 2019, he's never been to your residence, any place.
I lived in my home in South Fulton before.
See how she keeps going back to say where she lived at? See? Stay on that. I lived in my home at South Fulton, so she can vehemently say that he hasn't been there. But y'all was doing the bang bang boogie somewhere where you was laying your head at, lady.
Before I started getting the threats that were here, a house I paid for with my own sweat and tears. I'm no longer able to live there. But in 2019, I did. And in the 2 months of 2019 that I knew Mr. Wade, 3 months, the beginning of October, all of November, and all of
now
December,
she's so clear on
Mr.
these
Wade
details.
never came to my
Yeah.
house in South Fulton. Let me help you out. I lived there in 2020. He never came to my house in 2020, let alone live with me, as you put falsely in these documents. In the first 3 months of 2021, when I could still enjoy my home, Mr. Wade never came to South Fulton, and it is certainly a lie that he lived with me.
So in 2020, so you said 2019, 2020, did Mr. Wade ever visit you at a place that you
He has
resided?
never been to my home
Yeah.
in South Fulton.
She said, has he visited you at a place where you laid your head? She keeps going back to the home in South Fulton. This is how you can tell people lying. She's lying.
2020 was before I knew that a phone call was going to be made and I was going to have to abandon my home. As a result thereof, he never visited, lived at, came to, or has seen South Fulton.
You qualified that with your home in South Fulton.
That's where I lived in 2020.
2020, did he ever visit you at a place that you resided?
Okay, I don't understand. You want to give me that. In 2020, I lived in South Fulton.
Okay.
That's the only place I lived in South Fulton. That's before I had to abandon my home, Judge.
All right.
And at my
Well,
home
I
in
think we're
South
gonna clarify
Fulton,
this. We'll break it
Miss,
there.
he never came.
She over
okay?
talking
So
to
if you
Judge.
don't come someplace, you can't live there.
Ms. Willis, that's, I'm gonna have to caution. This is gonna be my first time out to caution. We have to listen to the questions as asked. And if this happens again and again, I'm gonna have no choice but to strike the testimony. So.
Yeah, look
we need to
there.
break this down. Ms. Merchant's
Whatever.
question, I
Look
believe,
at that. Did y'all see that?
asking whether you lived.
This is a judge.
I lived in South Fulton. That's before I had to abandon my
Dismiss
home,
him.
Judge.
All right.
And
Like whatever.
at my home in
We're gonna
South
clarify
Fulton,
this. We'll break it
Miss,
there.
he never came there, okay?
Look there. First, she's just talking over the judge. She has no respect for him either.
So if you don't come someplace, you can't live there.
Ms. Willis, that's, I'm gonna have to caution. This is gonna be my first time out to caution. We have to listen to the questions as asked.
Watch her.
And if this happens again and again, I'm gonna have no choice but to strike the testimony. So
Strike it then.
we need to break
See that? Strike it.
this down. Ms. Merchant's question, I believe, was asking whether you lived anywhere other than South Fulton.
I did not live anywhere but South Fulton, Georgia in 2020. That is before I began my prosecution of this case, and it was my plan to only live there.
Did Mr. Wade ever visit you at the condo that you leased from Miss Yurdi?
He visited that condo, yes.
He did.
Yes.
Did he ever spend the night at that condo?
No.
He left
Just
before the
visited.
sun came
He
up.
did visit for sure.
Did you ever go out to eat together, other than the lunches you talked about,
In
during
2020?
2019 or 2020?
I would think that we probably went to lunch, but it wouldn't have been,
I would.
let me think, 2019. I'm gonna say,
2019.
I don't know, I'm gonna say we probably broke bread someplace in 2019. I don't remember it, but it seems like we
Remember it.
broke bread sometime in 2019. So I'm gonna say yes, although I have no recollection.
I have no recollection.
But it seems to me like I go out to eat and drink with pretty much everyone, so
Yeah,
I'm gonna
no,
say
yeah,
yes.
I'm gonna say yes.
So outside of the vacations that we've already talked about,
He's-
did you ever go out to dinner with Mr. Wade?
I mentioned to you that I
I'm gonna object as to what time period. Like, we're asking very vague questions. I thought we were treating the witness as hostile on the 6/11. We're no longer doing that. So we're gonna go back and forth. We need to be more specific with our questions if we're gonna treat her as hostile.
All right, Ms. Merchant, it's not so much. I think you can elect between leading and open-ended questions, but I think we are still wondering about, and I think we need to get back on track of focusing on the financial benefit or the relationship.
And my next question about if you did, who paid when you went out to dinner?
He paid, I paid.
You both paid.
Okay, so let me be real clear.
More proof when people lying, they always, make the facial expressions and stuff. Like, come on, like the sky is green. What are you talking about? The sky is green. Everyone knows that. Like, really? What are you like? Duh.
Clear. We didn't say, oh, the bill is $102. You give $51, I'll give $51. I don't operate like that with my girlfriends. I don't operate like that with anyone. He caught the bill, I caught the bill, whomever.
Did you ever pay him through Cash App?
No.
You only ever paid him through cash?
Well, yes. We're talking about, I'm very confused.
You've
now.
never given Mr. Wade money through Cash App?
No.
The only money you've ever given him outside of a contract is cash.
I didn't give him money in a contract, so that was cute, but I didn't give him money outside in a contract. What happened? No, we're gonna answer it since you said it. He worked more hours than he was paid, and the county paid him for the work that he did. So don't be cute with me and then think that you're not gonna get an answer.
And I will ask you about the contract in a minute. I asked you about cash. Did you ever pay him anything? And I'm trying to qualify my questions. I'm not talking about the contract with Fulton County that was paid. I'm not talking about that. I'm talking about outside of that. Did you ever pay him anything other than cash?
I've only given him cash a few times in the course
Either
of
yes or no answers again. But liars do this. I've only given them cash a few times. Like, why didn't you just say yes or no? It's either yes or no. And look at the face again. Trying to make the person asking the question appear stupid or dumb for asking the questions. These are manipulation tactics.
So if we would go to dinner,
Let her finish her answers.
if we would go to dinner, I wouldn't give him cash because he paid for dinner or I paid for dinner. I've given him cash only a few times in life, probably 4. Probably the most money I've ever handed him is $2,500. The least amount of money I've handed him, probably between $500 and $1,000.
You never wrote him a check?
Ma'am, I don't have checks.
Okay. So you have no.
Again, yes or no. But she's got to try to demoralize the woman by going, man, I don't have checks. Why couldn't that just be no? But see, she's doing this to try to get into the psyche of the attorney who's asking her, Miss Merchant, who's asking these questions and stuff. These are tactics used by liars.
Proof of any reimbursement for any of these things because it was all cash, right?
The testimony of one witness is enough to prove a fact.
So my
Are you
question was,
telling
do
me
you
that
have
I'm
any
lying to you?
proof?
Is that what you're intimating right here?
I'm asking if you have any proof that you paid him any of these
The
monies.
proof is what I just told you.
Everything is get
You
defensive.
have no written proof. Is that correct?
It's get defensive.
So I have some, probably some transactions like in Belize. I probably spent $500 on my card in Belize. I spent $900 on each of our tickets to go to Belize. I did the $700. I probably got some minor expenses in Aruba that would be on a card. But for the most part, for those trips, other than.
Stop right there.
So
remember when she said that first, at one point in the beginning of this here, she said that she paid the tickets and then Mr. Wade paid the tickets. And now she's saying again that she has paid the tickets. So which one is it? If you paid the tickets, why did you reimburse him? Why did you reimburse him?
Oh, the 2 cruises, I gave him money for those before we ever left. Because they were pre-booked. Let me answer.
The question was if you had any written proof. And so
I've answered you that I've had written
we
proof.
can move to the next question. If you've answered if you had any written proof, and that was my question.
I want to make sure that we're clear that for the 2 cruises.
Judge, I asked if she gave him written proof.
We're not going to talk over each other. Ms. Merchant, she answered your question, so we can ask the next question. Ms. Willis, Ms. Cross will have plenty of opportunities to let you clarify your answers when it's her turn.
Thank you, Judge. Knowing your role as district attorney, you know that public funds are scrutinized and money is scrutinized and things like that. You understand.
I'm sorry, go ahead.
You understand you're under a microscope. You have reporting requirements, all of those types of things. You have no record other than your testimony of the money that you've given Mr. Wade.
You've already asked that question. Let's keep going.
When you took office, you had a tax lien of $4,600. Did you pay that with cash when you made that tax lien whole?
What?
I probably paid through,
The thing.
however you pay.
Yeah.
Okay. So, but you were saying that you had amounts of cash. You still had that lien in 2022 when you were dating Wade and going on these trips. So the cash that you gave him, that could have been used to pay this tax lien off?
You gonna tell me how to pay my bills?
Object. This is not relevant as it relates to why we're here today.
Yeah, because if you had cash like that, why would you, and you're supposed to be the DA, owe taxes? So this right now, she's just put herself in jeopardy for tax evasion. She just admitted that she had the money to pay the government, but she didn't. You owed the IRS, you have a tax lien that you didn't pay, but then you are spending cash money that's untraceable. You the DA, lady, come on now. Come on. And you looking at her like she's stupid?
Mr. Merchant, are you trying to establish that she was insolvent in some way?
I definitely was trying to establish that she did not have these mass amounts of cash that she's talking about. Yes.
She is. Thank you.
All right.
Yes.
Re-ask the question.
You had a tax lien in 2022, $4,600.
Did you say I did?
Mm.
And you did not use this cash that you had to reimburse Mr. Wade to pay that off, correct?
No. I went shopping too when I didn't pay it off.
And you talked about, you gave a lot of interviews to some authors and a book called Fani Willis, right?
I would not characterize it as a lot. I probably have spoken to them 2 or 3 times.
My question is relevant as to.
I think it's already come up that finances are discussed in the book. I'll overrule that.
Thank you.
Ms. Wilson, you can continue your answer.
What came up with Mr. Wade as it relates to hearsay statements that he was asked about in relation to what Ms. Willis may or may not have said in relation to an author. So it's not relevant to the testimony that's occurring at this time.
I think Ms. Merchant has said that inside the book, she also makes a statement as to her own finances, and that's at issue.
So you gave interviews to the authors of this book, correct?
Once or twice.
Okay. And
just to be comprehensive, I don't know if it was 3 times, 2 or 3 times, I think.
you were quoted in the book, and I will give you a chance to say if this is a misquote. You were quoted, when they asked you about if you wanted to run for office for DA, you were quoted, "I really don't want to be financially effed up again." Do you remember saying that?
So what that refers to,
my question first is if you remember saying that.
I remember saying something similar to that, but I would like to be able to explain what that's in reference to. That's not in reference to anything else. It was a huge sacrifice to be district attorney in Fulton County, huge. I was doing just fine. I had a municipal court judgeship that was paying me $100-something thousand a year, and like you got to show up twice a week. Easiest thing I've ever done in life.
Wow. So she's lazy. She wants to have an easy job. And listen,
I also had private clients that were paying me to represent them. So I was able to have a law practice and that. Raising 2 daughters by myself, there were times in life where things were hard. And so I was telling people, I don't really run for DA. I don't want to run for DA. I'm in a good position right now. I got this easy job that I enjoy, being the chief judge of the city of South Fulton. I'm making money at the law firm, and I'm not sure that I want to make this sacrifice. And why does it always have to be me? Eventually, I prayed. I think that I was the appropriate person. I think that I did that. So when you're referring to that, what I'm saying is, why should I make a sacrifice again? And what I was not talking about is being district attorney. Once you get elected district attorney, you're in a fine financial position. I make over $200,000 a year. What I was talking about is I ran for judge. When I ran for judge, I took $50,000 of my personal money out of my retirement, and that money ended up being lost. And I know.
All right, so she just said she lost the $50,000, right? Earlier, she said that she had kept some of the money from when she was running for this office here.
When you bet on yourself, you're going to have to bet money on yourself. And so what I was talking about was not wanting to go through the personal financial expense of running for office. By no means did I think that I was going to be financially in a bad position once I won. Let's talk about what I was up against, because it's important to understand that comment. I had a district attorney who had been here for 24 years.
And Judge,
People, no, it's very relevant as to what my mindset was about this. So I'm trying to answer your question. So what I was saying is
Tailored solely to finance.
right, but it is about my finances. If I didn't, nobody put me in this seat. So I had already run for office once. I had spent $50,000 of my own money running, and it was vamoose, nothing. And so when I'm talking to those offers, I'm talking about the contemplation of the sacrifice of the run, not the sacrifice of once you become DA. The odds were against me. I was likely going to lose the election based on who I was running against.
I'm Black.
So that needs to be in the appropriate context.
Isn't it true that the authors also wrote, and you can dispute this if you'd like, that you were broke after that race?
The 2018 race.
Yes.
Yeah, that was a hard race. I wasn't broke like I didn't have any. So broke is relative to depending where you are. But
now she's gonna walk it back, right? Because if you was broke, then where'd you get the $2,500 here, the $2,500 there, the $2,000 there, the $1,000 to give to Mr. Wade?
that hurt to lose that $50,000. So I'm sure my mental mindset was like, I just gave $50,000 away.
Right. So they characterized it from their conversations with you that you were broke. You had poured your own money into the campaign and you weren't able to pay your own bills because of your clients couldn't pay their bills to you, and you had a paltry array of family and asset forfeiture cases. It says you were trying to make it month to month. Is that an accurate depiction of your financial situation at that point?
I would want to read that, but I don't remember clients not being able to pay their bills. Or
may I approach Judge?
You can.
You may.
Page 14.
I have not read this book.
Let me see this book. Let me see the number.
So like this fact here, her ex-husband Fred had run into a financial, I have no information about that.
See, now she picked a little part in the book to say that she don't have any knowledge about, right? But it doesn't go with the question that she just asked her.
About what they represent from their interviews with you, that you were broke and that you had clients that weren't able to pay their bills.
Can you show me where that is? Because this is where you put the tab, so that's where I read.
Broke, couldn't pay their bills.
Yeah, I'm sure I characterized myself as broke as leaving that $50,000. I don't know that I had her nascent law practice at paltry array.
Well,
I didn't have.
Ms. Merchant.
I thought I had a law practice. So this is not correct. I'm sure it's just I didn't have any asset forfeiture cases. So I had one case where they had took one of my clients' money at the airport. I don't know if that's what they're I don't know. Paltry array. I did have family law cases. I guess that's what they're talking about. And clients who couldn't pay their bills ain't clients. So no.
So my question was just if this was a fair and accurate representation where it says you were trying to make it month to month at that point.
No, I don't think that is actually a fair and accurate representation, but I am certain that after the 2018 election, I'm still not really happy about having given up that $50,000.
You know when you paid your tax lien?
I don't.
You don't? Do you know if you paid it?
I know I paid some taxes.
I know I paid some taxes. See, this way it's not a lie because I say I know I paid some taxes. She asked you about the tax lien. This heifer ain't paid her tax lien, but you got thousands of dollars to be, putting out there that you have not reported to the IRS. You should be ashamed of yourself.
I don't want to speculate.
Did you tell anyone at Fulton County Board of County Commissioners about your relationship with Mr. Wade?
No.
Did you disclose your?
No. See how she's doing that again, right? This is a mental manipulation tactic to mess with the esteem of the lady asking her the question so she could feel dumb. She's trying to purposely make her feel stupid for asking these stupid questions.
Relationship to anybody at Fulton County?
No, I don't think so.
And as the chief law enforcement officer of Fulton County, I assume that you're familiar with the county code and ordinances?
I've said we're not going to cover that in this hearing, Ms. Merchant.
I'm sorry, Judge?
I think we said we weren't going to cover the county regulations.
Okay, and I won't. Let me ask you this then. So are you aware that you're required to disclose any relationship with someone that you contract with in Fulton County?
Going to object to the court prior ruling that you this morning made.
Would this be different because it's a potential for impeachment?
Yes.
What did you ask me?
Ms. Merchant, if you could re-ask the question.
Okay. Are you aware that Fulton County requires you to disclose any relationship with someone that you're doing business with?
I'm not aware, and I know often that things are confused.
I'm not aware. Should have stopped there, but now she got to put more story so you can understand why she can say that she wasn't aware, right? And you, the whole district attorney.
With state constitutional officers in county, but I'm not aware.
Okay, so it's your understanding that you don't have a duty to disclose the
She's
relationship.
answered that question. Let's keep going.
Did you keep track of this cash that you paid him at all?
What are you talking? I don't understand.
Did you keep track? Did you keep a ledger? Did you keep track of it?
So I've only given him cash, as I mentioned, 3 or 4 times. There's no ledger. This is friends handing money off to each other.
So the answer is no, you didn't keep
I
track.
think you've already asked whether there was any written proof whatsoever, and she's
Yes.
answered that.
Okay.
So we've covered this. Let's move on.
Who were you referring to when you suggested that Mr. Roman's motion to disqualify was racially motivated?
We already said we're not talking about the forensic misconduct that's been alleged.
And
And just so the record is clear, I don't believe I said that his motion was racially motivated, so I don't want that to stay there. I've never said his motion was racially motivated, so that should not be
Ms. Lewis,
true.
I
if
think
she
it would
wrote
be
that.
best if we don't need to go down that road. We're going to save that for argument.
you once said that you would not engage with a personal relationship with anyone that worked for Fulton County. Is that correct?
An employee?
Anyone that worked for Fulton County.
I think I said an employee.
Okay. So that's the qualification you give an employee? You would.
I think that's the statement that I made. So if you want to quote me accurately.
So it's your position because Mr. Wade was not an employee, or it's your position he wasn't an employee, correct?
Mr. Wade is not an employee, and he will tell you that over and over again.
Just 1 moment, Judge. I'm sorry, the statement, just so I make sure I accurately quote you. What you said was you won't sleep with people who work under you. Do you not consider Mr. Wade working under you?
I consider Mr. Wade to be an agent.
An agent?
Yeah,
All right.
an appointee is what I really think of him as.
Your point, whatever merit it has, Ms. Merchant, is on the record. Next question.
All right. So, that's it.
Do we need any moments in a minute? Mr. Sadow. All right.
Wait, I want to see this guy. I love him. He's good. Watch him. He's gonna have her on the road. Yeah, I'm gonna let y'all go.
I'm going to try to ask you questions that you can actually answer without having to explain. Okay?
Yes, sir. My comprehension skills are pretty good, so we should do all right.
We shall soon see. If I heard you correctly, you moved into what I will refer to as the Yurti condo in either March or April of 2021. Is that correct?
Sometime between late February and April. Yes, I don't. Just so we're clear, yes. But in that time period, you're in the ballpark. We're in the ballpark.
And is that Yurti condo, would you say that it is in Hapeville?
It is in Hapeville, yes, sir.
And you moved in there for safety reasons?
My father, yes, I moved in there. We were concerned. My father was terribly concerned about me continuing to live at the house. And so they were clear. People came to my house at 5 o'clock in the morning about the police brutality cases, saying I was going to have a wake-up call. There were security threats due to gang cases. And there were concerns due to that was at the very beginning of this, looking into that. And so for all of those reasons and what was happening, my father wanted me out the house, and begrudgingly I left.
Okay, so the answer to the question was a yes for safety reasons, correct?
Those were all of the things that caused the safety concerns. I'm sorry.
I'm not questioning whether they were or are not safety concerns. I just asked that you moved into this condo, the RT condo, for safety reasons, right?
Yes.
Okay. At the time that you moved into the condo, be it from February to April of 2021,
Yes.
was your father still living in your house?
Right, because my father.
That's all I ask you.
But I get to explain the answer, sir.
I don't know if there's an explanation. If I ask you, was your father still living at your house? The answer is either he was or he wasn't.
Yes, but you are going to get to argue at the end of this, as we both know.
I'm not going to argue anything. I'm going to ask.
Be able to explain why.
I'm going to.
So yes, because my father is an older gentleman, he was worried about COVID and he stayed.
Ms. Willis, I'm going to have to say that's second time. Whenever we have to put a pause, you stop testifying, okay? You'll have a chance to explain yourself.
Well, you told her
The
you
question
were
was
give her warranty.
whether your father was not staying there at the time, and
That's why
you're clarifying
that
that
brushed them off, because she
in your answer as well.
don't have any respect.
You can have a brief clarification, but it shouldn't be something that reaches well beyond the question. All right, Mr. Sadao, you can re-ask the question. We'll see where it takes us.
Okay, thank you.
Bowing down on her.
Was your father still living in your house at the time you moved to what I would refer to as a Yurti condo?
Yes, sir, he was, due to his concerns related to COVID.
Okay. The safety concern was that there was potential danger at your house. Is that correct?
Yes, my address had been exposed, so yes, there was concerns about potential danger at my house.
Okay, so anyone staying at your house in the time period after you went to the Yurti condo was still in danger, correct?
Yeah, well, no, he did.
I think you have to, it's your attorney, Ms. Willis. Sorry, Mr. Bott, your objection is speculation.
Yes.
To the question of
Speculation.
whether someone was still in danger at her condo.
I can
Just let her answer the question.
Or Mr. Sadao wants to rephrase.
No,
I'm not
I
sure.
was able to understand it.
I've got the objection, and then I have.
I'll withdraw the objection.
You look, she's so eager to tell this lie that she's not even understanding why her attorney is trying to object, so she doesn't have to, because she's going to be incriminating herself. If you moved out for safety and it was in a safe place, why is your father and your children still there? And then she said earlier that the father and the children weren't there.
Okay.
So, and I remember the question, so I can answer it.
But you can, now that the objection's been withdrawn, can you try to answer that question?
Yes.
There's still a safety concern for people staying at the house.
Yes, I was very concerned about my father still living at the house. However, if you have dealt with an older gentleman, he was not leaving the house, despite my urging him that I thought he should leave as well. He did not want to leave the house because he was particularly worried at his age about COVID. But that became I don't want to say I was not happy with that decision of my father's, but I can't ultimately make him leave. And he stayed there too long, in my opinion.
Thank you. During that period that you left to go to the Yurti condo, did any of your children stay at your house?
So I don't think that they were there at that point. Certainly my baby wasn't there.
Right. See that? I don't think. That way I'm telling the lie, but I said I didn't think. That way, if someone calls me back on it, I can throw in there that I said I didn't think.
Talking about this entire period, we're talking about, if I remember correctly, and you'll correct me, I'm sure, you said that you stayed there at what I would call the Yurti condo until January of 2022. Correct?
Yes.
Okay, so I'm asking you, in that period, which would be February to April of 2021 until January of 22, did any of your children stay at your house
And you don't have to yell at me. I'm able to understand. So I would ask you to not yell at me. That being said, I don't actually expressly remember, but I can tell you since I have left my home, there have been times my oldest daughter came in, but I can't tell you with certainty the time window that you've said, if they did or not. And so I don't want to speculate to that, but there was some time that my oldest daughter came back, whether it was that period or after I left the Yurdi residence, I'm not sure. Okay.
Okay, so if I continue to go into more detail on this, you're not going to be able to give me an answer of whether or not, in fact, any of your children were still at the house or stayed at your house during that time period, correct?
What I can give you clarity of so that we are clear is from the time I moved out in February-ish of 2021, after I left there was a time period that my oldest daughter came back. But if you're asking me, was it in that window or after, I just don't have a recollection of that because, you know, your kids come and they go. And so I don't remember the specific time period, and I apologize for that.
Did your children ever stay with you at the Yurti condo?
Like maybe a night, like for a girls' night or something, but live with, no.
Okay. Did anyone else stay with you at the Yurti condo, including Miss Yurti?
Never. Miss Yurti never lived in the condo. She met her husband and they moved. They weren't quite married, but they moved. Nobody ever lived with me in the condo. That was
my word was stayed, not lived. Stayed with you at the condo.
I guess I don't understand the distinction, but no one ever, I think my baby's my oldest child. I think she spent one night with me, maybe my oldest and my youngest.
It's a good question. Balance says, how did she get to DA job? She continues to say she does not think. Why have a no thinking DA? I agree. That's why I'm saying, y'all, these people, these Black people, most of these Black women being placed in these positions are corrupt. And they are using Black people's emotions to pursue these goals. They are manipulating us by using emotional triggers, throwing the race card out there, and being a Black woman.
But I think that whole time I was in that place.
I'm thinking for you.
Other than that one night, I don't think anyone ever, there was a very lonely period in my life. I don't think anyone ever spent the night other than maybe one night. I remember a picture of my baby sitting on the couch in that place. And I'm thinking she spent that night, but just a very lonely time in life.
Okay, we'll stay with the lonely theme just for a minute. Did Nathan Wade visit you at the Yurti condo from the time you moved in until he was hired on November the 1st of 2021?
So I moved out of that condo, but during that time period, I'm sure he came to visit. He came to visit. I can remember us going, I think the restaurant's Lickety Split. I can remember him picking me up, going to Lickety Split and ordering some food and coming and sitting at my table and eating. So I remember times that he visited me at that condo. Yeah.
Okay, could you give us an approximation of how many times Mr. Wade visited you at the condo?
I don't think so.
Between the time you moved in and prior to November 1 of 2020?
I don't think often, but I don't want to speculate.
Can we say more than 5, more than 10?
Well,
I'm going to tell you the problem I'm having here. Let's say more than 10, but I'm not sure that that's even accurate. He certainly has come and picked me up, gone to grab some food to eat. I don't remember him being in that condo a lot. I'm sorry. You want a number, and what I don't want to do.
Your current and best recollection is all I'm asking for.
That's all I can give you, sir.
How many times did any of the prosecution team, how many times did Anna Cross come to that condo between the time you moved in and November 1st of 2021?
I don't think Anna's ever been to that condo.
What about any other prosecutor that's involved in the prosecution of this case?
I don't think any of them have.
Just Mr. Wade.
That's correct, sir.
That's it. was the only
But
D.
it was a lonely time.
Oh my God, that 2021. I have a lot of guilt about this time period in my life. Let me tell you why. But yes, it was a lonely time.
Okay.
I was very appreciative to the citizens for giving me this responsibility and this duty. But what I very, very quickly learned is that this is a very isolating job, and 2021 was a lonely time. I turned 50 in 2021. That's probably one of the worst birthdays I've ever had. I spent it alone. So I have a clear recollection of 2021 being lonely.
Did Mr. Wade ever visit you at the condo, the time period I'm talking about, prior to November of 2021, when Miss Yerty was at the condo?
So Miss Yurdy and me, we didn't share the condo at the same time.
So the answer would be no.
But we never stayed there together, so it's an impossibility.
It's an impossibility.
Yeah.
Okay.
Now, Miss Yurdy, because we need to get clarification on this. Miss Yurdy stayed in that place. There may have been a time that me and Mr. Wade visited, like went and saw Miss Yurdy, but me and Miss Yurdy never lived there together.
Yeah.
Just so we're clear.
See how she kind of scrambled that up there, right? Just so we're clear. So yeah.
Well, maybe that was clear, but I'm going to have to try again.
Okay.
Was Miss Yerty still living in the condo when you moved in?
Not a day.
Okay. So what I'm talking,
misrepresentation in this. We never lived together. I never lived with Miss Yurdy.
my question though, I'm trying to understand
Okay.
that after you moved in to the condo, Miss Yerty she was out of the condo, right?
She got a house.
That's all I'm asking. She's not in the condo.
We never stay, Miss Yerty and I never stay a day together in the condo. All of her stuff was out of the condo, and all my stuff, some of my stuff, not all of it obviously, was moved into the condo. So we never stayed there together. No, sir.
All right. So when I asked you about Mr. Wade visiting the condo when you were staying there,
Yes,
Miss Yerty wasn't staying there, correct?
that would be correct. Yes.
She wouldn't be at the condo, correct?
No, she would not have been.
It would be you and Mr. Wade alone at the condo, correct?
Yes.
That is, there weren't any other witnesses to Mr. Wade and you at the condo, correct?
Yes.
No security, none of your security detail.
Would object. She said it was just her and Mr. Wade.
You made your point, Mr. Sadow. Let's move on to the next one.
Yes, Your Honor. Who in the prosecution team prior to, I guess, the motion being filed by Defendant Roman, who in the prosecution team?
What these answers mean, like what angle, like what truth does she need to try to cover up here? Because liars never know exactly, what they have to say in order to, dispute the truth. So she's listening and trying to figure out like what the angle is so she'll know how to answer.
Knew of your personal relationship, and now I'm talking romantic, with Mr. Wade.
So, sir, I am extremely private.
All I asked is who knew. It's not, the answer is no one knew, that's fine.
No.
I ask you who knew.
Answer
me just tell you
it
this.
and then explain this, Willis.
I am very private. When I supervised Mr. Body and Mr. McAfee,
She still didn't even answer the judge. The judge told her to answer the question, then explain. She's going with these explanations first to avoid answering the question.
they didn't know who I was dating, but I can assure you I was dating somebody. So that I kept something private, that's my private life, is not any mystery to anyone. It's like a woman doesn't have the right to keep her private life private. And I'm speaking on this because there have been all these intimations.
You still haven't answered the question, Ms. Willis.
I'm sorry, what was the question?
Is there anyone else who knew about it? And then you can explain.
I don't know. I don't think so. I certainly didn't go out telling my business to the world.
Okay, so the best of your recollection, you didn't inform anyone on the prosecution team that the individual that you had chosen to lead the prosecution team had a personal relationship with you.
So
Is that correct?
That's inaccurate. Your question is inaccurate.
What?
Because you stated that the person I chose We had a personal relationship. So we had a friendship. We have all these distinguishing factors. Remember, when I chose him in November of 21, first of all, let's get this straight. Mr. Wade was not actually my first choice. That's no insult to him. No, it is because of the way you phrased the question. You said, when I chose him, I didn't inform people of a personal relationship. We have defined personal as romantic. It is an inaccurate way to state the question.
Then I will certainly restate it so it is very accurate.
Okay, and please do not yell at me.
You hired Mr. Wade for the first time on November 1st of 2021, correct?
November of 2021, yes,
Okay.
sir.
Your testimony is, whether one accepts it or not, your testimony is that at the time you hired Mr. Wade, there had never been a romantic relationship with Mr. Wade before you hired him, correct?
Yes, my testimony is that we were very good friends, but we're talking about sex, so let's just don't.
No, I'm not talking about, I'm saying romantic relationship doesn't necessarily have to be just sex. It can be dating, it can be holding hands, it can be any of those things that one might call romantic. I'm asking you whether or not prior to November 1st of 2021, there was a romantic relationship with Mr. Wade. That's very simple. It's either a yes or a no.
I don't consider my relationship with him to be romantic before that. I'm not a hand holder, so no.
Now, see what I tell you? So I don't consider, right? So not a yes or no, but I don't consider. And then she states because she's not a hand holder because he mentioned holding hands. So this way she can argue the fact that we didn't hold hands. So therefore it was not a romantic relationship.
That's fine. Now, let's move beyond November 1st of 2021, excuse me. If I understand your testimony, there was no romantic relationship with Mr. Wade until early in 2022, whether it be January or February or March, early in 2022, correct?
I would say sometime between February and April. Yes, sir.
All right. Now I'm asking you about that time period when it became romantic.
Yes.
Okay?
Thank you.
Okay. You didn't see the need, if I understand, to tell any of the people on the prosecution team when you had established a romantic relationship with Mr. Wade that the lead prosecutor, that is the man that was basically giving orders to others, was dating or having a romantic relationship with you, correct?
I'm going to object to relevance at this point, Your Honor.
Relevance.
Just to prove or attempting to show that there is an issue on the credibility about the relationship. The failure to have informed anyone on her team that she was having a romantic relationship with the lead prosecutor, I suggest gives rise to that inference. That's the relevance.
The inference that
they
see, she's trying to think, so she's listening, so she's trying to see like where he's going with this so she can have an idea of what explanation
they were concealing this because it was not as it's been characterized to the court, and that in fact it started earlier than what they say.
All right, overruled. Mr. Sadon.
I just want to make sure that we're clear. From at least 2020, me and Mr. Wade were friends. At least that time period.
Okay, I'm not talking about.
So no. I want to be clear because my credibility is being evaluated here, right? We were friends. We hung out prior to November of 2021. In November of 2021, I hired him. I do not consider our relationship to have become romantic until early of 2022. Because I don't know a date and time, I'm saying sometime between February and April of 2022, and very early April of 2022, because I know that trip that I discussed with you was like the first week of 2022, that the relationship had become romantic. I hope that answers your question.
That was the first week of 2022. So I'm sure y'all didn't go on no trip and no hanky-panky was involved. Let me pull this back a little bit. See how they throw the truth in there and then smear it up so you may not have heard it.
Was dating or having a romantic relationship with you, correct?
I'm going to object to relevance at this point, Your Honor.
Mr. Sedano, relevance.
Just to prove or attempting to show that there is an issue on the credibility about the relationship. The failure to have informed anyone on her team that she was having a romantic relationship with the lead prosecutor, I suggest gives rise to that inference.
Yeah.
That's the relevance.
The inference that
that they were concealing this because it was not as it's been characterized to the court, and that in fact it started earlier than what they say.
all right, overruled. Mr. Sedano.
I just want to make sure that we're clear. From at least 2020, me and Mr. Wade were friends, at least that time period.
Okay, I'm not talking
Okay, so
about.
no, I want to be clear because my credibility is being evaluated here, right? We were friends. We hung out prior to November of 2021. In November of 2021, I hired him. I do not consider our relationship to have become romantic until early of 2022. Because I don't know a date and time, I'm saying sometime between February and April of 2022, and very early April of 2022, because I know that trip that I discussed with you was like the first week of 2022.
The first week of 2022. So if they had a trip the first week of because it was New Year's. So that's a damn lie. You ain't go nowhere for no New Year's Eve, and you ain't did the thing. So if you saying it didn't happen until February or April, then what happened with your trip New Year's Eve? You know y'all was hitting it.
That the relationship had become romantic. I hope that answered your question, but I can't have it where.
I hope that answered your question.
You know, we're saying something differently.
All right, so you've established the timeline as you put it. The question originally was, at that time, did you tell any other prosecutors on the prosecution?
I never tell people at work who I'm dating.
All right, Mr. Seda.
Again, trying to make the person asking the question feel stupid. I never told anybody who I'm dating. Like, you know full well that this is improper.
Okay. Did you take any trips to DC with Mr. Wade?
Never.
Did you take, okay, so you have no, what I would call personal trips or business trips to DC with Mr. Wade?
I never went to DC with Mr. Wade, personal, business, otherwise, never.
Okay, so.
I've never been in the District of Columbia with Mr. Wade or Maryland, Virginia, the DMV as they call it.
So as I understand it, just to be clear, any trips that you would have taken to see DC would not.
That was a pretty clear answer.
Huh?
That was a pretty clear answer. She just said no.
Twice.
So do you have a variation or something new to bring up?
I'll ask it and we'll see. Did you take trips to DC that were non-business during the time period that this case or this matter was under investigation?
I'm going to object as to relevance as it relates to the matter that we're here before Your Honor.
Well, again, the question already asked is take personal or business trips. She said.
But that was with
Personal
Mr.
or
Wade.
business.
That was with Mr. Wade. This I asked her alone whether she took.
Okay.
What's the
And
relevance?
what would be the relevance of that?
Trying to understand whether or not we have an ability to show a personal trip in which Mr. Wade is there at the same time. I understand her answer. Okay, I understand her answer, but we have documents, we have records that.
Your Honor, I'm going to object to the documents, the things that.
Well, this could be something that's maybe not part of the record yet, but if he has I think there have been other things discussed in this case, and they have evidence that Mr. Wade may have been in DC at the same time. If you want to ask about that exact specific date, Mr. Sadon, you can do that.
I would reference to the court that was not asked of Mr. Wade. Anything about any trips to DC.
Sure. And so that's going to limit its merit and impact and on credibility. So Mr. Sadon, ask the question.
So
I understand your testimony is you never took a trip to DC with Mr. Wade.
That's correct.
Personal or business?
That's correct.
Were you ever in DC at the same time as Mr. Wade?
I was not.
On personal or business?
No, me and Mr. Wade have not been to DC at the same time. However, since Mr. Wade has been on this case, he's been to DC. Since Mr. Wade has been on to this case, I've been to DC. What has not happened is we have not been in the District of Columbia at the same time. Now, the only thing I'm not sure about with what you asked me is if I've been to DC personally, because I got a lot of personal friends in that area. But I know that I have been to DC. I did an interview at Howard University.
See that? Now he ain't asked none of this stuff. None of that. See, now she's going on with some stories so she can have an opportunity to talk and set the stage and then distract from the original question.
I went to DC for that. Seems like I've been to DC one other time. Oh, I went to DC for the Global Summit.
Oh, yeah. I remember.
Yeah, those were two separate trips.
My next question is based on her opening the door, and therefore I'll just ask it and Your Honor can decide whether or not it's appropriate. When you went to DC, did you go to the White House?
I did not go to the White House.
No, well,
Apparently I'm going to get the answer anyhow.
there you have it. Next question.
Okay. You indicated your best recollection was that your relationship with Mr. Wade, the romantic relationship, ended, you left it in August of 2023. That sound right?
That's the hard conversation. That's not the.
We've covered this. Next question.
And you characterized it as a tough conversation, correct?
Yes.
I'm not going to get into the conversation per
We
se.
should.
Well, if he doesn't want to, we won't go there. So, Mr. Sadon, next question.
You know, it's kind of hard to say no when you've got that opportunity. But all I'm going to say is, was it pre-indictment in this case?
So.
We know the timeline that the indictment was delivered.
Let me be
Well,
clear.
And so that we're
I'll give you
clear,
that.
the
Okay.
physical relationship ended pre-indictment.
And is that when you were talking about the tough conversation?
But I'm not sure that the tough conversation didn't happen until after, but the physical relationship. So I'm sure if you ask Mr. Wade, because he's a male, he would say we ended June or July because physical contact ended then. Just in my.
But if the physical relationship ended pre-indictment, how did you say it started after you hired him? She said that the relationship didn't get romantic until after November 2021, after she hired Mr. Wade. And now she's saying that the physical relationship ended pre-indictment.
Mind being a woman, it's over when you have that like hard conversation. I just think women and men think differently.
And I think the answer, Mr. Sadon, to your question was she's not sure whether it was before or after the indictment.
Well, I'm not sure that was her answer, but let's see if I can get specific.
That is what I said. That's what I said.
I'll let you. Next question, Mr. Sadon. If you need to
Want to
clarify.
say one more? The romantic relationship ended before the indictment was returned. Yes or no?
To a man, yes.
She just like, I'm not going to answer your question. To a man, yes. Right? So this way you can't corner me into a lie.
To a man, yes. To you, no?
She's explained this, Mr. Sadon. She's explained this.
And did the forthcoming indictment have anything to do with that? Or was it just a coincidence?
Let's go on and have the conversation.
I've just asked you whether or not it was a coincidence.
Had absolutely nothing to do with this. It's interesting that we're here about this money. Mr. Wade is used to women that, as he told me one time, the only thing a woman can do for him is make him a sandwich. We would have.
See, now she trying to use the whole being a woman. You know, women are looked at, looked down upon, right? Mr. Wade told me this day. See, now she's trying to steer the conversation to paint herself as a victim again here.
Brutal arguments about the fact that I am your equal. I don't need anything from a man. A man is not a plan. A man is a companion. And so there was tension always in our relationship, which is why I would give him his money back. I don't need anybody to foot my bills. The only man who's ever foot my bills completely is my daddy.
Is there anything else you would like to add to that?
No.
Sure.
But I'm sure we'll talk about it further.
No, we're not going to talk about it further.
All right, no back and forth. Let's stay down. Next question.
My next question is something that that has to do with what I characterize as the
jail
churches.
time. That's perjury. She should be facing consequences for lying in court. She should also be facing some tax evasion. Because she straight out admitted that she had thousands of dollars in cash, but did not pay the government. And you are a government official. You have an elected position. How can you owe taxes? I think they're going to be making examples out of these Black women. Her, along with that Mayor Tiffany Henyard, also as well. I think the FBI is investigating her. You know, they allowed them to enough rope to hang themselves, and now it's time to go to to the go to the walk the plank.
Speech. Let me just tell you what the question is, because I know that's not something.
Preserve it for the record.
Huh?
You can preserve the question for the record, but then we'll move on.
That's correct. Thank you. When you gave what I've referred to as the Martin Luther King weekend church speech, you know what I'm referring to?
A great honor of mine. That's a historic African-American church. Yes, I do.
Okay. Did you have handwritten notes with you that you were reading from during the speech?
And on second thought, Mr. Sadal, because you might have a number of questions about this, why don't we just bullet point what you would want to cover on this, preserved for the record, and then we'll move on to the next topic.
Okay.
Since I had laid out before that the forensic misconduct isn't a subject.
So do I not get an answer for that?
That's right.
Okay. Did you read your speech?
Well, no, Mr. Sadal, for everything related to any forensic.
Oh, you just want me to stay out of it now?
We're just not, we can do it in a bullet form if you just want to cover what you would have asked, but it's not in a question and answer format.
Okay, so I should do that at this point or do it
Sure.
when you're ready?
We can do it right now, so it's fresh on.
I'm going to ask her about, did she prepare the speech?
See, look, now she is trying to listen to find out what the questions will be so she can formulate what the story to go to match his questions. Look at her face. She's listening.
Did she have notes on the speech? Did she read the speech? When did she do this? When did she write the speech? Who was she referring to when she was talking?
We heard today in his closing arguments, he went back to this and stated that she did have notes and that she was reading, right? See, like this here is old, but what we had saw earlier was today, the actual closing arguments live, real time. So now going back to this, it makes sense on this question that he's asking her here, where she's like, kind of digging her own hole per se.
Talking about others, who she referring to when she said they, who she was referring to when she spoke in terms of that is.
I would love to answer those questions.
Well, Ms. Willis, you could certainly do that in some other format, but for today, that's what we decided we're not going to cover.
Who was she talking about that was playing the race card, and why she didn't tell people at the church that she had a personal / romantic relationship with the, all due respect, the way it was characterized, the Black man that she was referring to, and was the Black man she referring to, was that Mr. Wade?
Okay.
That's that area of inquiry.
Noted for the record, Mr. Sadal. Next topic.
Okay. I realize that you've testified that you have no records that with regard to cash payments.
Yes.
Correct?
Mm-hmm.
Would your bank records reflect that you withdrew cash from your bank accounts
during the time period of 2020, 2021, 2022, or 2023? I'm not asking you, I'm just asking whether they would reflect that you withdrew cash from any of your bank accounts.
So the exact amounts?
No, just
Yeah,
that you did.
See there? So the exact amount as opposed to yes or no.
Of course, I withdrew money throughout that time period, throughout my life. I withdrawn money from the bank. Yes, of course.
Talking about cash from, that is that you go to a
Cash,
bank
right.
or you go to an ATM
Cash.
and you take cash out.
Either that way, or you go to Publix and you overpay, or you go to another store and you overpay. So yes, both through that. Yes, of course they will reflect that at times.
Okay, and so those records, if we had them, would show that, correct?
That throughout the course of my life, I took out money.
I was very specific. I said
Yes, during the course of
2020.
that time period, I would have taken money out. Yes,
So do you have a problem with,
I absolutely. Yes,
you don't want the bank records to be made available for the court and the court
I'm
alone?
going to object as to the relevance, and this has already been addressed earlier as it relates to other records. This is an improper line of questioning. He's doing it for the purpose of harassment. Right.
I'm just going to sustain it on relevance. Mr. Sadow, if that's something you want to follow up privately, you can do that.
Last area, briefly.
yes, sir.
You had contact with Mr. Wade in the year 2020, correct?
Ooh, I had some contact with Mr. Wade.
Would you explain when you say some contact? Please tell us, talking about 2020.
I had some contact with Mr. Wade in 2020. One of the reasons your allegations are so preposterous on Ms. Merchants that you have joined is.
Ma'am,
No, no,
I
no,
didn't
no,
ask you about the allegations. I asked you about your contact. That's all I ask you. Okay? I appreciate that you want to say something, but I'm interested in, did you have contacts with Mr. Wade in 2020? And your answer so far has been yes, correct?
Very limited contact because Mr. Wade had a form of cancer that makes your allegations somewhat ridiculous.
I do appreciate the
I'm not going
characterization.
to emasculate a black man, but I'm just telling you.
Wow. She went there. Emasculate a black man. Wow. Wow.
I'm sorry, what?
I'm not going to emasculate a black man.
How?
Did you understand that?
All
So I don't
let's
think
get
we should
back on
discuss
track.
further.
Mr. Sadow, next question.
Trying to, Your Honor. Would you tell us on the occasions in 2020 that you
She went there.
had contact with Mr. Wade?
I'm sorry. I thought I had answered that. Yes, sir. There were times in 2020 I had contact, but 2020 was a year I was running for office. It was a year that he was going through some serious medical issues, and I did not have much contact, but I certainly had contact with him in 2020.
Did you go out to eat with him?
Maybe, probably.
Did you visit him in any location, his office, or did he visit you in your office in 2020?
I am sure I'm sure. Ooh, that's a very good question. I'm sure he came to 750 in 2020.
750
was my office.
Yeah, she
Okay.
Not often, but maybe once or twice.
Yeah.
Maybe I went to his office once or
It's a
twice.
distraction.
Maybe once.
And the
So we
purpose
can-
for going to his office
She's
would have
saying
been,
this stuff so we can have a little sympathy. Oh, he was battling cancer. Oh, wow. And you know, to distract from the truth.
what?
Maybe we would have went to Mellow Mushrooms for pizza, or maybe he would have come for lunch. I'm sure we went by each other's office though, but not often, not a lot. We both grinding, trying to make a living.
I understand what you've said about the cancer, and I'm not going into that. But when you were going out with him to restaurants, or when he would come to your office, right? Those were not sterile environments, were they?
Oh, very sterile, because it
The
was
restaurants were sterile environments?
a lot of times we wouldn't eat there. We would pick up something and go in, but they were
I'm listening to you. You pick up and take it to where?
Maybe eat at our office, but it did not happen much. That's what I'm trying to.
Oh, he called her up. Pick it up and take it in there. Listen to what she said. Let me just go back this a little bit.
Though, but not often, not a lot. We both grinding, trying to make a living.
I understand what you've said about the cancer, and I'm not going into that. But when you were going out with him to restaurants, or when he would come to your office, right? Those were not sterile environments, were they?
Oh, very sterile, because it was.
The restaurants were sterile environments?
A lot of times we wouldn't eat there. We would pick up something and go in, but they
pick up something and go in. Go in where? In the restaurant?
They were.
I'm listening to you. You pick up and take it to where?
Maybe eat at our office, but it did not happen much. That's
maybe eat at our office.
What I'm trying to explain to you. And my office in 2020, nobody was coming in. I was stir crazy, so I would still go into my office. If you remember, when I started this, I said, I am not even sure if we came to each other's offices, but I am trying to be over cautious. So I think I can recall him at 750 a couple of times. I just think I can recall him at 750 once, but let's say twice.
Yeah, they was doing the
I have seen his office. I remember all the awards in the lobby, but I'm not sure in 2020 I went. I'm not even sure I went in 2020 at all. I just want to tell you yes, because I'm not sure. But I have a distinct recollection of him at 750. I actually don't have a distinct recollection of me at his office in 2020, but maybe I went to his office in 2020, maybe.
Did you have ongoing phone conversations during 2020 with Mr. Wade?
Oh, yeah, I talked to, yes, absolutely. Yes.
Yes, no question about that.
No question. I talked to him on the phone in 2020.
I understood, and this is, maybe I was confused. The Belize trip was for
his 50th birthday.
His 50th birthday, and that was in
March. He turned 50 March 18th of 2023. If you look at the dates of the trip, I think we were there about 6 days. We stayed at 2 different locations.
And you paid for it?
100%. He said, I paid for the hotel, I paid for the flights, I had a birthday luncheon for him, I paid for massages, I paid for everything.
And would those payments be reflected on your credit card?
Cash.
You paid them in cash?
Cabs. I was telling you all the different things.
I'm asking you whether or not those payments would be reflected on credit card bills of yours.
So there was about $500 that I think is reflected on a debit card. What my recollection is, I took about 4 in cash with me today.
400 or 4,000?
4,000. But I remember I handed him 2,500, and then the rest was just the money we spent. I probably gave $300 or $400 to this guy who was a taxi driver. He would drive.
Wow. Okay, so if you paid for everything, why did you give him $2,500? You paid for everything.
Drive us every day around the 2 or 3 days we went. Took him to eat like it was my trip money.
And you had, to be clear, to end this up, the 4,000 that you've just told us.
But I didn't give it all to him. Remember, I only gave the 2,500 to him.
I didn't ask you that. I was going to ask you that 4,000 is part of my words, cash hoard that you had collected over time.
Cash what?
Hoard, H-O-R-D-E.
Oh, I thought you said something different, sir.
No, I'm afraid I wouldn't say that. Any circumstances.
Yeah.
To you or in.
All right, back on track.
Cash hoard.
I would not classify it in that way, but I have money at my house. Yes, sir.
And the money, when you had money at your house.
I'm speaking too loosely. I had money wherever I was staying. So I was not referring to my house in 750. I'm saying I had money wherever I was laying my head.
First she said he wasn't at her house. So 750 is the address to her house. She said back here, he was there.
Of the reasons your allegations are so preposterous, or Miss Merchant. I am sure I'm sure, ooh, that's a very good question. I'm sure he came to 750 in 2020.
Wow, you see that? When earlier she was absolutely, he did not come there. And see, she keeps switching it up, calling it 750. First, she called it her home in whatever city it was. And now she's switching it up to identify it with a different name to distract people, because I just called it. 750 is the address to her home. And here clearly states 2020, he was there.
My office.
Okay.
Not often, but maybe once or twice. Maybe I went to his office once or twice, but maybe once.
And the purpose for going to his office would have been what?
Maybe we would have went to Mellow Mushrooms for pizza, or maybe he would have come for lunch. I'm sure we went by each other's office though, but not often, not a lot. We both grinding, trying to make a living.
I understand what you've said about the cancer, and I'm not going into that. But when you were going out with him to restaurants, or when he would come to your office, be reflected on your credit card?
Cash.
You paid him in cash?
Cabs. I was telling you all the different things.
I'm asking you whether or not those payments would be reflected on credit card bills of yours.
So there was about $500 that I think is reflected on a debit card. What my recollection is, I took about $4 in cash with me to that.
400 or 4,000?
4,000. But I remember I handed him 2,500, and then the rest was just the money we spent. I probably gave $300 or $400 to this guy who was a taxi.
See there with these little extra details that, don't forget I had handed him, $2,500. But just 2 breaths ago, you said you paid for everything. And before that, you said you reimbursed him. So if you pay for everything, why are you giving him money?
Driver, he would drive us every day around the 2 or 3 days we went. Took him to eat like it was my trip money.
And you had, to be clear, to end this up, the 4,000 that you've just told us.
But I didn't give it all to him. Remember, I only gave the 2,500 to him.
I didn't ask you that. I was going to ask you that 4,000 is part of my words, cash hoard that you had collected over time.
Cash what?
Hoard, HORDE.
Oh, I thought you said something different, sir.
No, I'm afraid I wouldn't say that. Any circumstances to you or in.
All right, back on track.
The hoard, cash hoard debt.
I would not classify it in that way, but I have money at my house. Yes, sir.
Okay. And the money, when you had money at your house.
I'm speaking too loosely. I had money wherever I was staying. So I was not referring to my house in 750. I'm saying I had money wherever I was laying my head.
So she just clarified that 750 is her house.
Yes, sir. That was my fault that I wasn't clear.
Okay, so when you were at what we've said, the Yerty condo, during the time period we've always discussed,
brought the money there.
That's where you would keep your cash.
When I stay there, yes.
Okay, that's all I have. Thank you.
All right, I want to see if we can get through a few more defense counsel if possible before breaking for today.
All right, so we're going to stop it there. And I'll be keeping posted up on his stuff too. So, but I'm just grateful that I got an opportunity to see this live closing today, because it really makes, I've been watching this here video of her with these lies and stuff, and also Mr. Wade's testimony and his attorney or ex-attorney, ex-partner testimony and stuff, to see these lies, and then also the ones, like how he wasn't trying to tell the story. It was almost like, he was being intimidated. You see here. Balance says, does HIPAA apply in court? Oh, because of his medical stuff? That's a good question. Yes, I believe so. That's a good point, Balance. That's a great point. Yeah, because she told his diagnosis and all of that attached to his name. That's a good one. Yeah. Yeah. She's guilty of multiple crimes here, multiple crimes, just like that Tiffany Hanger, mayor is too. She's run amok on these people and stuff. And so I'm going to be talking about these things too in the future, because this is the reasons, a lot of the reason why people say these negative things about Black women and stuff, blaming the Black woman for all these things, is because of the few wicked ones like this. That's why I always say that you can't say that all women are good and all men are bad, because there's this evil, wicked spirit. Let me just show her face up here. Oh, that's too small. I want to look like that. There we go. This evil spirit exists in men and women. And you have to be careful of women like this, because she is very dangerous. She's very dangerous because she is representing, Black women, but she's not right. She's not right. Anyway, so we're going to be talking more about that, and again, showing these obvious cues on when folks is telling lies and stuff like that. And it's to show y'all how these Black people are using these talking points to emotionally manipulate Black people into voting for her, voting for them, when they play that race card and stuff like that, because she was voted into this position the same as the Tiffany Henyard lady also voted in too. So, Black people, I just want us to wake up and recognize that the people that are keeping the chains of the bondage on you are a lot of times these Black people, these Black Democrats. They're just, totally making us a laughing stock, or making y'all a laughing stock. Anyway, so thank y'all so much for tuning in, and I'll see y'all in. Oh, you're welcome. Thank you, Balance, for hanging in here too, and all your comments and stuff too. All right. See y'all in another video. Peace and love.